was passed and that was put.
Is it a pen? Is it a new case or a
It's a
notice
new
has been
case, my
issued?
lord, but my interim prayer is still under consideration, my lord. Therefore, my lord, may I pray before your lordship, my lord, to release the case in any day in the next week, my lord.
Give a date.
My lord. On my lord. 27, my lord, September.
With the consent of the application of sponsor, I beg to mention item number 2, my lord.
Yes.
So here, my lord, I have to file an affidavit, my lord, being certain facts. I have already sent it for vetting, my lord, but I have not received it. My lord, some new development is there, my lord.
What new development?
My lord, there, my lord, he applied without channel and
Huh? He applied?
applied for the fraud without going to the proper channel. And the agency where he applied, my lord, they have received only the envelope with a blank paper. That a one-man committee was ordered, my lord. Inquiry committee. Inquiry committee report.
Okay, let him file. When will you file?
My lord, it is sent for very much 3 weeks. After vacation,
Mr. KK Parasat, Learned Counsel for the response number 1 to 6. Submits that affidavit, additional affidavit or
my lord.
additional affidavit has been sent for vetting and the same will be filed within
3 weeks. my lord.
within 3 weeks. This is the matter of the 3 weeks.
The lordship interim order will continue.
What is this interim order?
There is a one post cap reserved for. One post cap.
Interim order to continue till the next day.
And some date may be fixed, lordship, because the matter is somewhat very.
Yes, what did?
After
Why after vacation 3 weeks? Today's 19th. There's the question of 3 weeks after vacation.
12, 11 or 12, 11. Otherwise,
3 weeks.
Otherwise, pleadings are complete. Lordship may take it among hearing.
Today is 19.
12, your lordship.
16. 1610. No, 1610 will be last week.
Last week, your lordship.
Last week will be 2 months.
10th of month.
Ah.
10th of October.
10th of. 10th of.
How much? Interim order may continue.
Interim order to continue till the next.
Highly.
Lordship, in item number 4, Lordship, on last day, the direction was passed, seeking for assistance of Learned Advocate General, Lordship.
Seeking?
Honorable Court directed Learned Advocate General to appear and assist this Honorable Court, Lordship, in item number 4, Lordship. It's a case of non-payment of salary to the employees of water supply scheme, Lordship. Lordship, problem is, Lordship, day before yesterday, his brother died, Lordship.
Oh.
So he's in bereavement, Lordship. I'm praying for some accommodation. I have
His
informed
brother?
Yes.
Own brother.
Okay, right. Adjournment prayer has been made of the has been made on behalf of the Learned Advocate General Assam on the ground that his brother expired 2 days back. Accordingly, lead this matter after.
Lordship, after, Lordship may fix this matter on 3rd of October,
Lead
Lordship,
this matter on 310.
subject to other set.
Yes. Highly obliged.
Lordship, another 4 matters, Lordship, item number 7 to 13, Lordship. 7 to 13.
Ah,
In this matters, Lordship, I am appearing for PWD, Lordship. Our affidavit is pending, Lordship, not yet filed, Lordship. So I have informed the other side, Lordship, I would pray for some accommodation.
oh. Why the results have not been declared?
Not results, Lordship. In fact, Lordship, in the advertisement, subject was mentioned as diploma in civil engineering. But the petitioners are diploma in planning and construction, part of subject civil engineering, Lordship.
Not
Whether both the subjects are same or not, that is the issue before Lordship.
it's so.
And APSC has submitted it unless department instructs us, it will not be possible for us to consider other subjects. That is the issue, Lordship. That is why affidavit of department is necessary, Lordship.
So when are you filing?
Lordship will grant me 2 weeks time, Lordship will file.
Who's for the other side?
Lordship, other side, Lamet Kukenar is there, Lordship. I have already.
Item number 10 and 12.
Yes, so 7 to 13. He's asking for time to file his affidavit.
Yes, my lord, on last occasion, the department was supposed to file an affidavit.
Then
So on the
The
basis of
department was
this,
asked to file affidavit on last year.
there's no objection on that. But now since there is already big delay, already the ability to have been filed a bit earlier. But since now our senior councils are also today not present. So on the basis of the objection.
You file it, what is,
Filed outside.
huh?
Lordship.
Mr. P. Nayak, Learned Counsel for the PWD submits that affidavit, additional affidavit,
No, it is affidavit in opposition.
affidavit in opposition will be filed within 2 weeks. This is a matter after 2 weeks.
My lord, kind apology, can my lord, fix the date, my lord.
Yes, give me a date.
2 weeks, Lordship. Lordship.
5th October.
Lordship. Much obliged.
Wait, your lordship, I beg to mention of listing a matter, my lord. The matter didn't turn up for 1.5 months, my lord, more than a month, my lord. My lord, the matter is removal of employee from a local body, my lord. I mean,
Well, 1 month, there are cases which have not come
Well,
forward
I-
for years to get a
Right.
you wait.
responded, my lord.
You
and
you go to
affected,
the
my lord.
registry, you go to the registry as well. Yes,
And please, your lordship, I beg to mention for listing, so matter may become up motion on 21st. of the-
okay.
Twenty-two.
22? Oh, withdraw.
Please, your lordship, as per direction given by the petitioner.
Huh?
As per direction given by the petitioner, the matter may be withdrawn.
You have been given the benefit or what? Right. Mister, what is your name?
A.K. Hannan,
Your name is not here in the,
M.J. Gadir, on behalf of, I'm appearing on behalf of M.J. Gadir,
Mister?
M.J. Gadir,
No, your name?
A.K. Hannan,
A.K. Khanna,
Hannan.
appearing on behalf of Mr. M.J. Khadir, counsel for the petitioner, submits that instructions have been received from the petitioner to withdraw the contempt petition. In view of the submission made by Mr. Swenson, the contempt petition stands closed on withdrawal.
Likewise, my lord.
23.
Wait, the lordship. Further, here the petitioners are aggrieved by denial to their promotion to the post of inspector in Assam Police. May I just
Agree
read-
with what?
aggrieved denying their right promotion to the cadre of inspector of police from SI in Assam Police.
Where is the denial? Why?
So, Malad, before that, Malad, I'll just briefly indicate the facts, Malad, what has happened. Malad, 2007, there were an advertisement for filling up of 116 of post of SI in the Assam Police. Malad. Pursuant to that, Malad, a select list was published on 11/9/2008.
Where?
The petitioners' names were not there in the select list, and some other candidates, Malad, they have challenged the select list before this honorable court. Lordship will find page 41 for a moment, Malad. The order of this honorable court in the petition where the select list was challenged. Page 41. May I submit this, read the second paragraph. The council appearing for the government submits that the government is reconsidering the select list since the rules regarding the roster have not been properly followed. Therefore, the government would redo the select list as per the roster rules. It is also submitted that the person whose name were not even in the merit list also shown in the select list. Therefore, the entire select list is reconsidered in accordance with the merit and rules. And accordingly, this honorable court directed to redo the select list within a period of 2 months. But after 3 years, this select list was redone on 2/7/2017. And the petitioner's name were included in the select list. And subsequently, on 12/2/2018, the petitioners have been given appointment. After 10 years of the batch who has already been appointed in 2008. Now, thereafter, the petitioners were sent for training. They have completed their training on 8/7/2019.
What training?
The probational training,
Probational training.
probational training. And thereafter, they have been given their joining in their respective places. Now, 9/7/2021, page 60.
Yes.
Page 60, the
The candidates my lord, who were appointed along with the petitioners in the year 2008, the select list candidates, they have 49 batches. This was the 49 batch. They have been sent for a pre-promotional training for the post of inspector.
You are from the 49 batch.
We are from the 49 batch. The other candidates, everyone who were there in the select list, they have been sent for the pre-promotional training. Thereafter, my lord, but the petitioner's house was not sent for the pre-promotional training. We approached this honorable court, challenging that. But in the meanwhile, my lord, all the candidates were given the promotion on 3/11/2021. Page
No. 49 batch went for pre-promotional training on
Yes.
9/7/2020.
9/7/2021.
You are also 49 batch.
My lord, though we were appointed lately, but we ought to have been in the 49 batch because we were the candidates among the 49 batch, the select list, redone select list. But our seniority was not fixed at par with the 49 batch. And therefore, in the first round,
So those 49 batch persons, they were appointed when?
they were appointed in 2008 itself. Now, my lord, 3/11/2021, all the 49 batch people, they have been promoted to the post of inspector.
Inspector.
Now, your lordship will kindly find page 86 for a moment.
Page 86. Yes.
Page 86. Lordship will mark the date 22/3/2023.
Yes.
The second paragraph.
Yes.
Enters a seniority of the following SIUP, former SIUP of Assam Police, who were selected and appointed pursuant to advertisement dated 23/11/2007, has been refixed in the sequence given below immediately after the former SIUP Tutul Kutum 49 batch, the junior most officers appointed by the same advertisement. The allowances, pay and allowances of the officers mentioned below are to be counted from the date of joining in service at the initial pay of the pay band of the rank plus grade pay. No retrospective financial benefit will be allowed. These are the people, my lord. Now our seniority has been refixed with the 2008 batch. Now we come at
With the 2008 batch?
2008, 49 batch.
Yeah, yes. So
Yes.
you are 49 batch.
We were 49
So
batch.
they have put you below the last person.
Yes.
So
Initially in 2018, when we were appointed with the 51 batch. 53 batch.
in 2000,
53 batch.
in 2000 appointed when?
2018.
You are appointed with the 53 batch.
With the 53 batch.
So now with this page 86, your seniority has been placed along with the 49
Along with the
batch.
49 batch.
So what is wrong?
Now, no, there is no law. Now our seniority has been retained with the 49 batch.
Correct.
Now 49 batch has already been promoted in 3/11/2021. Your lordship has seen that. Now, thereafter, being aggrieved by not giving us the retrospective benefit, we instituted a writ petition that is 3835/2023.
335 of
2023. That is pending before this honorable court. In the meanwhile, the government also has has sent for approval of giving us the pay benefits also. That is page 96. Last line, Melo, to find. You were requested to convey government approval for conferring fixation benefit to the 10 numbers of SIUP at the earliest. These 10 numbers are the petitioners.
No, from which period? For which period?
Our fixation seniority has been fixed with 2008. In page 86, lordship has found that the pay benefits we are
No,
not given the
when you say 2008, from where you saying this word 2008?
page 86 for a moment.
Yes.
My lord, find former SIUB Tutul Kutum,
Yeah.
49 batch of 2008.
So you have been put below them.
Bit below. But that is seniority from 2008. This is,
Where is the seniority from 2008?
my lord, Your lordship will find Tutul Kutum 49 batch of 2008.
Correct. These are 2008.
Yes,
How, but where does it say that your seniority will be counted from 2008? Where does it say that? It just says that it will be put below this person.
yes. No, put below the person in the sequence, in the seniority sequence, I have put below the petitioners were put below Tutul Kutum.
Ah.
This seniority list of 2008. The
This 51 batch, this 51 batch have been 53 batch. They
they were of
when were they appointed?
2018.
Appointed 2008.
I have been given now.
Between this 49 and 53 batch, how many batches are there? There is 50, 51,
50,
52.
51,
So all dates are there between
yes,
2008 and
yes,
2018.
between the 2008 and 18. So now that seniority aspect, there is no dispute that I am at par with the 49 batch who has already been promoted on 3/11/2021. Now subsequently, my lord, now on again, a pre-promotional training was rescheduled and we were sent for the promotional training with the 58 batch. Now, lordship will find page 101,
58 batch.
my lord,
101.
along with 58 batch.
But you said pre-promotional training was done for the 49 batch
49 batch,
in 21.
yes,
You were not there.
we were not there.
Okay, so you have never been sent.
We were never been sent. We instituted a repetition in this before this honorable challenging that our names have not been sent during the pendency. Because the issue was
No, so what happened to that writ petition? What is the writ
That is-
petition?
that petition is still pending, my lord. That is 5482/2021.
548/2021. So you have filed already two writ petitions.
Two repetition. And when 5428/2021 instituted, immediately thereafter, they have refixed my seniority at par with 49 batch. I was not sent
So
for
pre-promotional training on page
pre-promotional
101.
training 9/7/2021.
9/7/2021. No.
Yeah.
No. At page 101.
Oh, page 101 is the recent one,
That is on 7/9.
7/9/2021,
7/9/2023.
2023,
With which batch?
with 58 batch,
5/8.
58.
So in 21, when the 49 batch went for pre-promotional training, you were not there. You were not included.
We were not there. And we were not.
So now you are claiming seniority. Your seniority has already been given with the 49.
With the
So
49
your
batch,
basic case is that you should have been promoted
along with the 49
that
batch on 3/11/2021. Now, Manoj, may I just clarify one thing? When 2021, the other people were sent for promotional training, we were not sent. And the justification which has been given by the government that our seniority is not at par with the 49 batch. Now, these issues are clear. My seniority has been given with the 49 batch. So therefore, immediately upon passing the pre-promotional training, I ought to have been given promotion with effect from 3/11/2021 with my batch. Now, this 7 September.
So now have you completed your pre-promotional
Yes,
training?
yes, my lord will find to page 20 is the result.
Look, pre-promotional training, this letter at 101
It is
is
the
of
res-
7/9/2023.
it is the result of the pre-promotional training.
It's a result.
Result of it.
So
My
when
lord
did-
will
so
find-
when did you have the pre-promotional training?
Page 97.
Say that. You see this small, you're not saying it clearly.
I'm
You
sorry.
said-
I'm sorry.
You
page
said that you were
97
sent for pre-promotional training
My lord.
only on 7/9.
No. Page.
Don't cut short
I'm
facts
I'm
and
sorry.
thereby make wrong submissions.
I'm sorry. 14/7/2023,
Page 97.
page 97.
14/7/2023.
14/7/2023. The lordship will find my names.
Oh, no, it's okay. So now
Now-
what do you want?
Now, 7/9/2023, We passed the pre-promotional training. All the candidates who had,
So you should, so you're saying that you should also be promoted with retrospective effect,
but,
at least the benefit
but,
of seniority
we,
without the pay.
without, no, my lord, with notional benefits.
Notional benefits means not actual benefit.
No, no, not
Notional means notional.
notional, notional.
So that's what.
Now, if your lordship finds 7/9/2023 is the result, all the people who has secured grade A and grade B has been sent for the promotion. Everyone who has secured grade A and B has been sent for promotion except these 10 petitioners. Now, if your lordship finds,
You have secured what?
I have
Yeah.
some petitioners A and some petitioners B.
So all those persons,
They are passed.
58,
They
they
have
have been given inspector post.
Yes.
You have not been given.
We have not been.
Why?
My lord will find 12/9/2021,
Page?
page 104.
Yeah.
This is the impugn order which we are challenging. Now, my lord will find the first paragraph I'll read, my lord.
Yeah.
What is the consideration? As recommended by the State Selection Board, the following confirmed SIUBs are selected for promotion to officiate in the rank of Inspector of Police temporarily in usual scale of pay and other allowances posted as shown against their name. They may be promoted accordingly, provided no departmental proceeding, court case, etc. pending contemplated against them, and the period of punishment, if any, or is not operative at present. They will retain their state substantive rank of SI in their case parent district organization. The promotion is considered in order of seniority and taking into account the provision of so and so as per post-based roster in pursuance of the order of the Honorable Supreme Court and government instruction therein. My lord, but I apprehend, my lord, that my refixation of the seniority was not taken into consideration.
Your
Refixation of my seniority with the
was not
49
taken
men
into account.
was not taken into consideration. That is what I apprehend. But if the seniority
Have you made a prayer in this writ petition that your seniority should be counted from 2008
yes, madam. No, my lord,
or 2007? When was it? When was
2008. My seniority has already been fixed with the 2008. There is no dispute. Government has refixed my seniority.
That is at page 1, page
86.
Page 86.
page 86. Yes, madam, I think you'll have to take notice.
Yes, lordship. Because this is a.
It seems you've got a prima facie case.
Lordship, this is well, but if your lordship may kindly peruse the impugned notification that
Yes,
they have
yes,
challenged lordship. Here it is clearly written that where departmental proceeding or court cases, whichever is pending. And admittedly, lordship, regarding their seniority position, lordship, one case is already pending. So this has to be decided, lordship, and I don't think that the prayer. that
Anyway, I
has been-
think you see, we'll tag all these cases and
Yes,
dispose
lordship,
it
it has
out.
to be heard properly, lordship.
Because there is you see, there are number of cases
Yes, lordship.
where, you see, sometimes what happens is they are considered against vacancies. Now, supposing a vacancy occurs in January and the selection process is completed, recommendations made, but appointments not done due to various reasons, maybe court cases also.
Lordship.
And in the meantime, in January, in February, March, vacancies, again, those are filled up, subsequent vacancies. Supreme Court has held that wherever those earlier appointments are not made due to some litigation, which is not the fault of these persons,
Yes, lordship.
then they have got to be given their seniority as per
Effect from
per the vacancies
Yes, lordship.
available.
Yes.
So they have got a case. I don't find any ground to obstruct their claim. Only thing is, now since they are saying that notional only, they'll get notional, that's all.
Yes, lordship.
Only seniority, notional pay you'll get.
With my prayer is for
Notional you'll get.
notional benefit with effect from 3/11/2021. Now, by this 12/9/2023 order, we have not been even given promotion, and this post will be filled up.
Anyway, problem is that
Notional.
we can't decide the entire case.
No,
today.
absolutely not.
We have got to get.
As an interim, what I'm saying.
And this is assumption only, if your lordship may kindly peruse. This is assumption. This may be because of this pending cases, lordship, because this is clearly written in the note
How can it be?
Why
an
these?
induction, my lord, when these, all these junior batches have been promoted?
And anyway, the thing is that you see, he's been put en bloc behind those persons who have been appointed in 2008. So there cannot be any inter se seniority issues
Lordship, this has already been.
between the,
That has been.
between the
positive
49
case of
batch.
Lordship, this is, I'm not onto this thing.
Okay, right. Third, Mister?
Only regarding Lordship, the interim prayer that has been made, Lordship.
Ah, no
Lordship will
interim,
need-
no interim.
My
No
lord,
interim.
Yes, Lordship.
my lord,
What,
your
what
lordship,
interim do you want?
my lord,
What
if
interim?
There I
the
have
person, my lord,
objected,
in
Lordship.
para 23 of my repetition, I made a categorical statement that though this order has been
No, no,
passed
no.
on 12/9.
It'll amount to giving you the final release.
Yes,
So, my lord,
Lordship.
and
We
then
will tag all these matter
Or-
together and we'll dispose
or
of
your
what.
lordship-
Only
or-
hearing
or
Lordship
your
may
lordship
issue
will
notice.
direct-
Mr. Council, otherwise,
my lord, or your lordship will direct not to fill up 10 posts, my lord, otherwise if
no.
the posts are filled up.
Ah.
Well, all,
okay,
my lord, that
okay, yes.
is the
Lordship,
protection. my
this will be,
You can always go in division bench.
Lordship.
Uh,
But Lordship may issue notice on the interim also, Lordship, giving us a short date. So that we can also, because.
But in
we-
the meantime, don't fill up.
Don't fill up.
Lordship, this is only the simple
You
notice
see,
based on
you see,
12 September.
prima
Lordship.
facie, I find
This
it
is an
got a
order,
solid
not
case.
notice.
Due to various judgments of the apex court, if you want, which I can put down here also.
But regarding this keeping 10 post Lordship,
Madam, what to do? My prerogative.
obviously Lordship's prerogative.
I find they've got a prima facie case.
Lordship.
Heard Mr. B. Kaushik, learned counsel for the petitioners, who submits that the petitioners had taken part in the selection process for filling up 116 vacancies
116 posts were advertised.
in the rank of sub-inspector
Sub-inspector, you.
of police. Sub-inspector or inspector? Sub-inspector of police.
Initial recruitment was sub.
Sub-inspector of police. Whatever I said in the beginning, Jeffrey. Pursuant to. An advertisement dated 23/11/2007. This one.
Lordship, whether the all 10 have cleared, this is also has to be.
I show.
He is given a affidavit, he's given it on oath. Why shouldn't I believe it? You see, unless and until you deny that statement by way of an affidavit,
Yes, Lordship.
it is deemed to be a truthful
Yes, Lord.
averment made by.
True, Lordship.
It is a writ petition, it is not the.
Because as this is
suit.
in the supplementary list, Lordship, also we did not have the opportunity of going through the brief. Only after coming to court, Lordship, I have gone through this. Is a
Yeah.
supplementary man.
My lord,
This also has to
it
be.
is not my statement, my lord, the result sheet that is published by them.
These are small factual disputes. If you find that they are wrong, we'll dismiss it on the
Yes.
next day.
Lordship.
KD Sharma's case, if they hide facts, do not
Yes,
come with
Lordship.
clean
Yes,
hands,
absolutely.
you don't have to go into the merits of the
Merits
case.
of the case.
So what is it? First up, though the petitioners have been selected for filling up the vacant post of SI of police, bracket UB, comma SM. In terms of the select list dated 11/9/2008, comma, the petitioners were not appointed to the post, while other persons whose names were in the select list were appointed to the post. Next para. Being aggrieved, the petitioners approached this court by WPC number,
Case 30.
just a minute,
Page
4435/2008. Bracket Shyamal Nyog, SHYAMAL Nyog and others versus State of Assam. and others. Also. WPC number 4435/2008 was disposed of by an order dated 14/7/2014 in view of the undertaking given by the council appearing for the state government to the effect that the government was reconsidering the select list as the rules regarding roster had not been properly followed. Full stop. This court, while disposing of 4435/2008, also recorded the following. You take it para in page 41 in blue, huh? Paragraph this. Okay. Next. The petitioner's counsel submits that subsequent to the order dated 14/7/2014 passed in WPC 4435/2008, the petitioners were appointed to the post of SI of police bracket UB along with the 53rd batch on 12/2/2018. Full stop. He submits that the petitioners belong to the 49th batch. And don't say he submits, he say comma, those the petitioners belong to the 49th batch. Full stop. Then what is this 8/7/19? What is this?
9/7/21.
That's right. Next,
8/7/19, they completed their training and they have been given
Okay.
the place.
next para, the first stop, next para. The petitioners counsel submit that the petitioners completed their training.
Right.
Uh,
Probational.
their probational training on 8/7/2009. Full stop. The 49 batch of SI bracket UB were called for pre-promotional training with effect from 9/7/2021. Full stop. However, comma, as the petitioners were not included among the 49 batch for pre-promotional training with effect from 9/7/2021, comma, the petitioners challenged the same by way of WPC number 5482/2021, comma, which is still pending before this. Full stop. The 49 batch SI bracket UB were thereafter promoted to the post of Inspector of Police on 3/11/2021. Full stop. Next para. The grievance of the petitioners with regard to their seniority not being considered along with the other SI bracket UB of the 49th batch was thereafter taken care of by the state government by order dated 22/3. No, wait, by order dated 22/3/23 issued by the issued by the Office of the Director General of Police, Assam, wide memo number. Is there any memo number?
Yes, my lord. Page 88 is the original copy. May I?
Wide memo number FA/148, no, FA/1/48/VOL -21/PT-Roman 2/2014/329, page 88. Huh? By the said order dated 22/3/2023, the petitioners were placed in the interstate seniority were placed. No, the petitioner seniority position were placed en bloc below, immediately below the former SI bracket UB Tultul Kutum of the 49 batch of the year 2000. Next para. And then this retrospective, this case 3835/2023, this has no value now.
But no, not giving us the pay benefit from in a retrospective manner, we challenge that in this regulation. In the meantime, government has,
You said that you are only wanting notional benefit.
no. My fixation in the SIUB cadre from 2008. I am praying in this.
So your
regulation to-
senior, once your seniority has been fixed, you should be getting notional from there.
Yes, and
So,
but by
okay,
this
right,
86 order, they have not given this.
The petitioner being aggrieved that the salary had not been fixed, correct?
Pay benefits.
That as the pay benefits had not been fixed notionally
Right.
with effect from the date the 49 batch of SI
Well appointed.
bracket UB had been appointed, comma. They filed WPC 3835/2023, comma, which is still pending in this court. First one. Yeah, retrospective pay the benefits and seniority. No, pay benefits only.
Pay benefit.
So that's kind, no change. Next para. The petitioners also submits that the petitioners were thereafter called for pre-promotional training along with the 58th batch, 58th batch of SI UB, SI of Police UB. By letter dated,
It's an email.
Oh,
madam.
huh?
It's an
By
email.
email dated 14/7/2023. And by letter dated 7/9/2023, the petitioners were shown to have completed the pre-promotional training along with the 50th batch, wherein they were given the grading of A and
and
B. Capital A, capital B. Next part. The petitioner counsel submits that the petitioners promotion should be considered.
12/9, the order has been passed. madam.
Huh?
Page 104,
Wonderful.
page 1. That is the order, madam, by which promotion has already been given to all the.
Ah. The next para, the petitioners were thereafter promoted to officiate in the rank of Inspector bracket UB of police.
Not the petitioners, madam.
Acha,
All the-
the petitioners council submits that the 58th batch of SI UB of police were thereafter promoted to officiate in the rank of Inspector UB of police temporarily. While notification number police 35/2023 dated 12/9/2020. Full stop. However, the petitioner's name. However, the petitioners, who belong to the 49 batch were not included in the said notification. Full stop. The petitioners have thus made a challenge to the impugned notification number police 35/2023 dated 12/9/2023.
To the extent, my lord, inclusion of the junior's name in the promotion. We have made them a party.
To the extent that the juniors of the petitioners who belong to the 58 batch,
Respondent number
58 batch have been promoted and by not including the name of the petitioners. So what about 50, 51, 52? They've all been promoted
This
earlier.
58 batch includes all, my lord. The 51, 52, and they have been, while
All
promotional
50,
training, they have been regarded as 58.
But their seniority position has also not been, is still pending, lordship.
That is why we have to decide the entire.
Yes, lordship. This was also because this is specifically, this is written as per, based on the seniority position.
Okay,
lordship.
we'll see, madam.
Seniority has already been fixed.
And right, issue notice, returnable in 4 weeks. Miss M. Bhattacharjee accepts notice on behalf of
1 to 4, lordship.
respondents number 1 to 4. Petitioner takes steps for service of notice upon the respondents number 5 to,
78.
how will you take
My lord, through the office of the Inspector General of Police,
5 to 78? Through the office of the
Inspector General of Police
Inspector General of Police,
Administration.
to the respondent number 3. To the respondent number 3. By registered post with AD, within
Within 5 days.
within 5 days. List the matter after 4 weeks. In the interim, the respondent should keep 10 posts of SI of police bracket UB.
Inspector.
Inspector of police bracket UB. Should not fill up 10 posts of SI of police, Inspector of police UB. Till the next returnable date.
High level. My lord, will take other three.
List this matter on so and so. List this matter after 4 weeks along with WPC 5482/2021 and 3835/2023.
3.
3.
High level.
Yes.
This matter, my lordship, filling up a vacant post of Gambura, and the same was still vacant, my lord, due to retirement of the petitioner's father. My lord. And then advertisement was issued, my lord, stipulating some eligibility criteria, and also it was laid down that the preference shall be given to the family member of the Gambura. My lord.
Advertisement dated
My lord, at page 22 dated, my lord, 1/12/21. 1/12/2021.
21 page 22.
20.
What are the conditions?
My lord.
What are the terms and conditions for a
Terms and
candidate?
conditions, my lord. Kindly see page 26. Clause C, subclause 1, 2, 3, other criteria.
Yes. Yes,
First dot, my lord.
yes.
Candidate should be a citizen of India and a permanent resident of the area in respect of which she seeks appointment. Then fifth dot, my lord,
So you are interested in which one? The,
only four conditions.
show me, which
Four.
one?
And then fifth dot, my lord, preference shall be given to the family members of Gaon Pradhan and views of the Mojada shall be taken into consideration. Then, my lord,
Just a minute. One is, candidate should be a citizen of India.
A
and-
permanent resident of the area.
Yeah, then
in
candidate preference shall be given to family members of Gaon Pradhan. And views of the Mawzudar shall be taken into consideration. Then next,
Then next 7, candidate should not be a member of any political party. If your lordship, page 27, kindly see. Clause G. Allotment of marks for valuable.
yes,
My lord, at serial number 4, Gaon Pradhan family of the Mojadar view, 10 additional marks have been allotted, my lord. In the interview, my lord, subsequently I have filed an additional affidavit, my lord. The marks have been supplied to me, my lord. It appears from the said marks evaluation sheet, my lord. That is page, my lord, 56. After compilation.
56. Yes,
56. Annexure 1, my lord.
yes.
My lord, serial number 1, the Keshav Chandra Boshu and similar to the Kandar Boshu, then respondent number 8, my lord.
Mhm.
The marks chief board member, my lord. The total given me 67 and Kandar Boshu, respondent 8 has been 78. Average 22.33 for me and 26 for Kandar Boshu. And medical 5 and 4 is generated and total final marks is 27.33 and respondent 8 has been awarded 30. But 10 marks has not been awarded to me, my lord. The additional marks. Whereas, my lord, the said respondent number 8, my lord, is not eligible in terms of the advertisement that is mentioned.
You're the son of the deceased, you're the son of the earlier Gaon Pradhan,
Yes, retired company.
retired,
Retired.
retired Gaon Pradhan.
Yeah.
There's the retirement age.
Yes, retirement date, he is retired on, my lord, 5/10/2021.
What is the retirement age? 92, 102, what? What is the
Actually-
retirement age of a Gaon Pradhan? 65.
65. Now, after amendment, there is no retirement age. my lord.
Now
Now-
there's no retirement age.
Yes. Subsequently. Then last one, he is not eligible because, my lord, kindly see page, my lord. He is a Panchayat member. He had contested the election from the BJP as a BJP candidate in the last Panchayat election, and he won the election. as
You
a-
won the election.
Yes, my lord, and he's continuing. my lord.
Okay, now, the first of all, the advertisement was issued on 1/12/2021. And now where is the, won the election where? Page?
My lord,
Where is the document showing that he won the election?
yes. My lord. Page 43,
43.
page 43. This is a document, my lord. He resigned from the post of PA and president forwarded it to the government. My lord, kindly see, may I read, my lord. A member of the association submitted a letter to consideration resignation from his post of membership on behalf of the council. We provided the letter and information, which will take exception. But this letter was forwarded on 25/5/2022, the date when the select list was published, my lord.
Let us see when was the select list published.
Select list, my lord. Page 38,
Page 38.
page 38. 25/5/2022. And this select list was made as per the marks obtained from the selection board, my lord. The respondent 8 name has appeared at serial number 33, page 39,
33.
serial number 33.
What is his name?
Kandarpa Bashya, my lord. Right side, Kandarpa Bashya. And if you look at the last page of the notice, my lord, 41, If your lordship kindly see page 41. The bottom sentence, my lord, at the bottom, my lord.
Yes,
The selection of candidate are purely temporary, subject to clearance of police verification, and if any unsatisfactory report found against the candidate, the selection of the candidates may be liable to be cancelled.
okay, then
And my lord, if your lordship can page 43, your lordship has seen
40?
43 already seen, my lord,
Yes,
and kindly see page 78. Page 78.
yes,
78, my lord, this is a certificate issued by the Gambura, my lord, kindly say, not top, my lord. Government Gambura village head, Shri Rajanikanta Das, Ambari, Nisbankhor, Remunu village, my lord. He stated the last paragraph, my lord. As I know, it is true that the said Kandharma Vishwa became the member in the last Panchayat election from the Bharatiya Janata Party, my lord. He is a Gambura from the Nisbankhor village, my lord. And my lord, kindly see the next page also, my lord. It is what annex, my lord, 868, 69, my lord. And 80, sorry, please, page 80. This is a ballot paper, my lord, which was looks an affidavit, my lord. And thereafter, my lord,
just a minute. Yes,
then, my lord, the government, my lord, submitted, filed is their affidavit, my lord, supporting the candidature of this selection of the respondent number 8, my lord. If your lordship take the affidavit in opposition filed by the respondent authority, my lord. That is at page 62,
yes,
paragraph, my lord, may I read paragraph 9 of that affidavit.
yes,
That with regard to the statement made in paragraph 8 of the repetition, the deponent begs to state that as per report of the circle officer, Hazor Avenue Circle, by letter date so and so, respondent number has also landed property under Sanpara Parvat village and has been living there since many years, my lord. And next page, my lord, copy of the circle officer report is annexed here and marked as annexure 1. Kindly see annexure 1.
annexure 1, annexure A.
Annexure. Annexure. This is the report, my lord, to the additional deputy subject regarding submission report reference and so. With reference to the subject cited above and letter cited above, I have the honor to inform you that Shri Kandarpo Vaishya, son of Bondiram Vaishya, who is selected for the post of Gapradhan at village Sanpara and Sanpara Parvat under Mauja Pubbankhor of Hazor Avenue Circle, is a resident of Nisbankhor, Mauja Pubbankhor, as per alarm report, my lord. My lord, the Gambura of the Nisbankhor village has certified that he is contested election. My lord, this report has not been challenged till date, my lord. And he is not the village of Sanpara Parban, my lord. He is a resident of village Nisbankhor. This is clear from the report. So he is not eligible as per the terms of the advertisement.
Yes,
And my lord, kindly see the next paragraph of the affidavit in opposition filed by the my lord.
para 10.
Para 10, my lord. With regard to the estimate made in paragraph 9 of the repression, the deponent backstage said that although the respondent it was an elected ward member of the 87 now Bankhor Gaon Panchayat and had contested and won the election from ward number so and so Panchayat, He offered his resignation on 29/11/21, my lord. Now the version is prior to the
Prior to-
advertisement, prior to the advertisement, my lord. My lord, this is the, my lord. Yes, he is the member of a ruling party, my lord. That's all, my lord. So had it been given,
Now let
the-
us see this letter.
my lord, had it been given the, my lord, 10 marks, I was selected. Then my marks would be 37, my lord. He worked in the 30.
Let us see this next year B.
Annexure B, my lord, page 68. With reference to subject, I would like to inform that in terms of letter and so report along with the said letter, so addressed by the CS and so the said member seeking resignation is also enclosed. Also enclosed letter then so and so, the further development with regard to the resignation of the controversial. This report is forwarded on the basis of the, my lord, the matter is not the resignation from the post of membership of the Gapoda. He should not be a member of the political party. He won the election as a member, my lord, from the BJP party, my lord. He member of the BJP political party, my lord. Resignation is not the question here, my lord. But they have projected a case.
Sir, this is- letter addressed by Zila Parishad says resignation as member, not from a political party.
My lord,
So his resignation,
from
as
member,
per this letter, page 68,
yes.
is as a member of that Zila Parishad.
Panchayat, from Panchayat,
As member of the Panchayat,
Panchayat,
not from the political party.
not.
Please read the Assamese version properly, page 69.
Hmm.
Is it correct?
Yes.
Then allowed. Allowed. Please read.
উপরোক্ত বিষয় ও প্রসঙ্গ নির্দেশৰ চিঠি সম্পৰ্ক সন্মান সহকাৰে আপোনাক জনোৱা যায় হয় যে যোৱা 21/7/2022 তাৰিখৰ HRS নাম প্ৰতিবেদনৰ লগত সংলগ্ন নথিসমূহ তদন্ত কৰি প্ৰতিবেদন প্ৰেৰণ কৰা হ'ল। মূল প্ৰতিবেদনৰ লগত খণ্ড উন্নয়ন বিষয় মহোদয়ৰ নাম্বাৰ ডেটেড 7/12/2021 তাৰিখৰ চিঠি মৰ্মে কামৰূপ জিলা পৰিষদৰ মুখ্য কাৰ্যবাহী বিষয়ালয় উক্ত সদস্য পদৰ পৰা অব্যাহতি বিচৰা চিঠি প্ৰেৰণ কৰা দেখা যায়। লগতে 87 নং বংশৰ গাঁও পঞ্চায়তৰ সভাপতিয়ে শুৱালকুছি খণ্ড উন্নয়ন বিষয়া মহোদয়লৈ প্ৰেৰণ কৰা চিঠি মৰ্মে শ্ৰী কন্দৰ্প বৈশ্যই যোৱা 29/11/2021 তাৰিখে সদস্য পদৰ পৰা অব্যাহতি বিচাৰি লিখা চিঠি সংলগ্ন কৰা হয়। এই প্ৰতিবেদন সংশ্লিষ্ট লাটমণ্ডল প্ৰতিবেদনৰ ভিত্তিত আপোনাৰ বিহিত ব্যৱস্থাতে প্ৰেৰণ কৰা হয়।
So what does he say?
But it said that he was resigned from the post from the Bangkok and that was forwarded to the
Was from a member of the Panchayat.
Panchayat, my
Ah.
lord. That was forwarded to the block development officer by the president of the Panchayat.
Okay.
Then
He-
subsequently it was sent to the Zilla Parishad, my lord. Chief executive officer.
So not a resignation from the political party.
No.
Anything else? That's all. Then so the respondent number 8 was appointed.
No, not appointed. He was selected. His selection has been stayed by this.
Okay, stayed by this court. Okay.
Appointment has been issued, appointed other candidate. He's not been appointed. His selection because the interim order, my lord.
Someone else has been appointed.
But remaining other persons has been appointed because
Actually, in other villages.
other vacancies.
And out here, you are the number 2 person. And you only 2 candidates.
Two candidate, my lord, because he is no, if he is not only, I am the sole candidate, my lord.
Yes.
Lordship, I shall not go into the details, Lordship, whatever, but I shall only submit that admittedly, Lordship, the advertisement was post 2018, Lordship. So there was a notification of
Post 2018.
18. 10th April 2018, Lordship.
The advertisement was 1/12 to 2021.
Yes, Lordship.
Ah.
Because 10th April 2018, Lordship, a notification was issued by the government of Assam, Lordship, which was published in the Gazette also. And this is some rules regarding the appointment of Gabuda and Latmandal has been Gabuda has been.
Is it part of the?
No,
Doc-
Lordship, this is what actually I'm saying. And the fact that has been stated by my
friend lordship, this is squarely covered by 162C provision, executive instruction provisions of 162C of the Assam Land Revenue Regulation, where lordship regarding any selection and appointment lordship. Appeal lies.
But no, it doesn't mean that it outs the jurisdiction under Article 226.
No, I am not onto that lordship, because where the alternative remedies are there lordship.
And the facts are so clear.
Alternative remedies are there
We
lordship.
see
So it
with,
should-
so according to you, alternative remedies. is
Yes,
for-
lordship.
Okay. That's all.
162C,
So-
and there is also provision of review also lordship.
So that is.
Yes,
your-
lordship,
that-
and the many number of cases have been
No,
referred.
no,
to.
any other point with regard to?
Lordship, because the
only-
appeal lies for this.
So,
the
so
selection-
you are confining your submission only to 162C,
Yes.
nothing
lordship.
else.
Lordship 162C.
That's all.
lordship, I shall.
Okay, so you are admitting to all the other facts. that means.
Because
Yes,
if
yeah,
there is
yeah.
any other issues lordship involved with this, so this has to be agitated before the appropriate forum, which is stated as per the Assam Land and Revenue Regulation Act lordship. This have to be followed lordship.
Yes.
I'm for the response.
Yeah, for the response number 8.
Eight.
Oh, very good.
I'll submit precisely your lordship. So before going to submit lordship, may I take your lordship to additional affidavit being filed with the
This
petitioner?
page.
Additional affidavit page 135.
Yes,
Annex B. So this document reflects that one appeal was pending before the divisional commissioner. Additional affidavit, your lordship, is fine.
My lord,
Annex B, just me. Annex B, page 135.
additional affidavit of the petitioner.
Yes.
Keshav Major so again the final. The hearing was 6 and 5.
It reflects that one appeal was
my lord, kindly
registered
say
and
the
that was dropped.
last order, my lord, 1/9/2023, that is clear. my lord. Last order.
1923 of this.
1/9/2023 of this. Last occasion also raised this question, my lord. The honorable court has clarified. That's why I have filed the additional. affidavit.
What is this forwarding letter?
My lord, the interim order,
Acha,
because
the
the
forward-
regional commission is also a party in this case, my lord. I submitted the interim order.
Okay, okay.
my lord. That letter was treated at the appeal, my lord.
Yes.
I have brought it to the notice of your lordship. Apart from that, his contentions is that respondent number 8 is not the permanent president of Sanbara Parvatya, your lordship. This is the first contention. And he raised that contention, he did not submit the certificate of the resident of that locality issued by the Mojadar. On this point, your lordship, may I clarify? I filed a reply. Your lordship may take turn to page 72 of my reply. If it in reply.
Yes.
This is the certificate duly issued by the Mojadar, Gongsar Mojar, certifying that. It's hereby certified that Wonderful Voices son of so and so. Is a
Page 72 is what? Page
of my
72.
reply, your lord.
Yes,
Affidavit in reply.
yes. Para 6. Which
My
para?
Reply affidavit, your lordship is annexure. Page 72.
I have got page 72.
In the
Page 72 is para 6.
affidavit reply filed by me. Your
File size. The compensation cases, they will have.
My affidavit, it starts from
You please show him this.
page 56.
Huh? You please show him this. Why don't you paginate your page along as the code file? So that we are on the same page.
Page 86, my lord.
Page 86, give me
Page
that.
It starts from page 86.
Page 86.
Come to the right side.
More reply to the same.
Page 86 the reply.
Page 86 is affidavit in opposition.
Yes, my lord, he is.
No, I am just submitting my reply. Reply affidavit.
Additional
How can
affidavit
it be a
opposition.
reply, Mr. Counsel? First of all, you're not a petitioner.
This is filed by him. Affidavit in opposition.
Yes, my lord, sorry.
Which page?
Your lordship will find it page 72.
86.
72.
Yes, my lord.
72 is the affidavit in reply filed by the writ petitioner. Are you the writ petitioner?
My lord, 72.
You don't understand.
My lord, 72,
No, my
102, my lord.
My paging is, I think wrongly.
My
No,
lord,
Mr. Counsel, let me be very clear. An affidavit in reply is usually filed by the writ petitioner.
Yes, my.
So how can you say it is your affidavit in
No,
reply?
my affidavit in opposition, your lordship.
Your affidavit in opposition starts from
In my, it starts from 56 in my,
86.
86, and he referring my lord 102, page number 102,
It is referred to 102.
wrong here.
internal
Sorry,
page
my lord,
70.
wrongly.
Anyway, it doesn't matter. We will
fine.
complete this case.
Yes, yes.
Yes, tell me.
102,
102 is in Assamese. I cannot read.
102,
Yeah, I have annexed the English version also before. that.
Where? Which page? Yeah, 101.
101.
Yes. What does it say?
It is hereby certified that Sri Kondarpo Boisa, son of late Bandiram Boisa, is a permanent resident of Sanpara Purple Village under Moja Pub Bangsar of Haju Revenue Circle, your lordship. His contention was that I was not a permanent resident of that locality, Sanpara Parvat Village. It has been clarified by the circle officer by issuing that certificate, your lordship. It was a contention of the petitioner. And
Yes.
and secondly, your lordship, he has contended that I am the member of political party. And because of that, he challenged it. Your lordship, may I take your lordships to the resignation, my resignation letter,
Page.
page more 77.
77. Page 107.
107, your lordship.
Yes. Where is the English version?
106.
106.
Yes.
Lordship to the block development officer because he was a member, he was elected as a member of that panchayat under the banner of Bharatiya Janata Party, the political party. He was a political member there. Politically, he was.
Mr.
elected.
Counsel, please read.
Yes, my lord. More respectfully, I beg to state you that Sri Kondarpo was a member of so-and-so. Bangsar Gao Panchayat submitted his application on 29/11/21 seeking resignation from his membership. We are hereby forwarding his application to your good self for taking necessary action. We request you to take necessary action on it. It is humble request before your good self.
Is Mr. Counsel, this is a resignation of your membership from the Gaon Panchayat, not from a political party. If you're going to resign from a political party, do you write to the block development officer that you're going to resign from such party? Who is the block development officer? Is he part of some political party?
From his membership, lordship, because he was
Mr.
appointed
Counsel.
politically under the banner of BJP. your
Mr.
lordship.
Counsel,
Yes, fine.
to be a member of the political party, whose permission do you take? Block development officers
No, no.
permission or what?
It's not my.
Who appoints you as a member of a political party or who accepts you? Does the government officer give you that thing, the permission?
No, because
This-
before
this-
that resignation, my lord, before that
Yeah.
resignation,
Okay,
he had to also withdraw the resignation from his.
where is that
party.
resignation?
That is a.
That is not here.
only.
That's it.
So
not here.
another contention here is that lordship, He just contended, I have not filed any online applications, your lordships. It was a contended by the petitioner. I have filed the online application 71 pages. My pages are 71. 101, your lordship.
That is not the.
That is so.
What 10? What is the issue? 101. We have already gone through 101.
Yeah, yes, my lord. So that is my submission.
What about that Mozadar? 10 marks. Is he the son of the retired Gan Pradhan? No, according to you, no.
That is my submission. Yeah, so far
Okay,
executive.
so your submission is twofold. One is you are a resident of that Sanpara,
Yes, my lord.
and number two is that you have resigned from the membership
Yes, my lord.
as a member. That's all. That were 2 points.
Yes.
I'm applying for number one.
Who is the respondent number one?
Revenue department.
Revenue.
Yes.
Yes, what is your case?
Already my senior colleague has submitted that there is a appeal provision. There has to be.
Okay, appeal provision. ठीक है.
Yes, regarding the preference part.
Huh?
Preference, it should be more marks.
हाँ.
As in, I want to place on judgment lordship.
Yes.
Report. Para 16. Only one copy. Para 16. Preference will come only one, 2% max 12 marks. This is also pertaining to department of ground.
That is not a preference is when they are both having equal marks. His case is that as per this clause at page 56. Page 56. Not 56, sorry, 27. Gaon Pradhan family member Mozadar view, 10 marks. But how do you know you will get 10 marks out here?
My lord, kindly see page. Page 30.
32, yes.
Mozilla view, my lord.
Yes.
My lord. It is certified that on retirement of Sri Lal Mohan Bashya, Gaon of lot number 4, Sanprabha Science under Mozapu Bonkor of Hazur Administration, his son Sri Keshav Bashya has applied for appointment. Sri Keshav Bashya, son of Sri Lal Mohan Bashya, is resident of the above mentioned lot. In my knowledge, his moral character is good. He has the experience of duties and responsibilities of Gaon. I wish him all the success. The views of Mozilla. Additional marks on this basis. That's it. I have whatever I have submitted to it. Citation. That is these has been also passed on the basis of in relation to appointment of Gaon. So yes, this has been considered the preference.
You see, that is preference will only come when the marks are equal. But that is a different issue.
Not
Out here.
admittedly, he is getting less marks than
He- yes, but admittedly, he is a member of a political party. Then? What about their contention that an appeal provision is there? What to do?
Yes, my lord. My lord, that is there is a discussion of this honorable court matter. And at this belated estate matter, that they have responded this my contention matter, both respondent aid and the respondent government law. And even if my lord, I would like to place honorable Supreme Court judgment.
Yes,
matter.
please.
There are my lord, three exceptions, my lord.
Yes,
In my lord, can you see, they must Godrej Sarali Limited, my lord.
yes,
My lord, in paragraph 4, 6, 8, my lord.
yes.
Yeah, my lord. Said that even if there is a statutory, my lord, provision not applied, if there is a violation of the principle of natural justice or violation of any fundamental rights, my lord, then your lordship exercise the discretion.
There's no violation of principles of natural justice
My
here.
lord, my lord, I had submitted and complained before the deputy commissioner, my lord, that he is not eligible, and I have been not,
But deputy commissioner is not the authority to hear the appeals.
yes, my lord.
Is the deputy commissioner the authority to hear the appeal?
Oh, yes, first, he is the authority, my lord.
He is the one to select, not to hear the appeal.
No, my lord, kindly see the.
Who selected respondent number 8? Who selected the respondent number 8?
Yes, my lord, the selection with deputy commissioner, my lord.
Selection committee is made up of whom? DC?
Yes,
Then
yes,
can DC hear his own case? Supposing I pass an order,
Yeah.
you want to appeal, can I hear my own appeal? Then,
then the division
then,
commissioner. But my lord, here is the, my lord. My lord, at this belated stage, my lord, the pleading is, then at this stage, my lord, whether it will be, my lord, to send the petitioner to the mill of appeal in hierarchy, my lord.
okay, anyway. So that, yes, what?
Regarding alternative remedies.
Huh?
Regarding alternative remedies, okay. One judgment, okay. 14-1 SCC 603, lordship.
Give me.
Para 14, 15, 16, and 17. Para 14, okay. In Union of India versus Guwahati Carbon Limited, this court reiterated the hypothesis principle as observed. Before we discuss the correctness of the impugned order, we intend to remind ourselves the observation made by this court in so-and-so versus so-and-so. In this decision, this court was pleased to observe that a revenue statute provides for a person aggrieved by an assessment thereunder a particular remedy to be sought in a particular forum in a particular way. It must be sought in that forum and in that manner, and all the other forum and modes of seeking are excluded. Paragraph 15. Thus, while it can be said that this court has recognized some exceptions to the rule of alternative remedy, that is, when the statutory authority has not acted in accordance with the provisions of the enactment in question, or in defiance of the fundamental principle of judicial procedure, or has resorted to invoke the provisions which are repealed, or when an order has been passed in total violation of the principle of natural justice, the proposition laid down in so-and-so and other similar judgment that High Court will not entertain a petition under Article 226 of the Constitution if an effective alternative remedy is available to the aggrieved person, or statute under which the action complaint of has been taken itself contains a mechanism for redressal of grievances still holds in the field. Therefore, when a statutory forum is created by a law for redressal.
Is this a statutory
Statutory.
provision? Is it statutory?
Yes.
Or is it an act? or a regulation
Yes,
it
Lordship,
is
land
made
revenue
under-
regulation.
made under what? Made by whom?
This is executive
Executive
instruction.
Assam land
It's an
revenue
executive
regulation.
instruction. It is not an act.
Yes.
There's a difference between an act. Is it an act made by made by the legislature?
Yes, Lordship,
Assam Land Revenue.
Assam land revenue regulation act.
It
Lordship.
has been framed.
Regulation act.
Yes, Lordship.
Executive instruction, my lord. It is not passed by the parliament, my lord. Let's.
If it is passed by the assembly, that is law. That is statutory law.
An executive is not an estate.
Huh?
It's not an estate.
Uh, you've got you seem to have a prima good case, but the problem is this alternative remedy. Show me the executive instruction made under what law? Otherwise, what we can do is, we can stay the thing till you go there.
My lord, and even now the divisional commissioner has been abolished, my lord.
Acha,
Yes, now.
Ah,
There is an other problem has been active, but he's the also the party here, my lord, in this proceeding, my lordship. And under 220 lordship and is not.
it's a regulation, it is not an act.
Yes. 86.
So it has to go before whom?
Lordship, commissioner. The commissioner is the second appellate. Divisional commissioner. As per the rule. Amendment. Lordship, kindly as per notification letter 77/2023, the power vested upon the divisional commissioner has been transferred to divisional commission, principal secretary, general administrative department.
No. This court can do it. There's nothing which says that, there's no appointment order. What can be appealed against is an appointment, suspension and dismissal.
Yes, Lordship.
And in this case, it is selection only.
Lordship.
Selection
That
is
has been,
there.
that has been clarified by division honorable.
My lord,
In that case, my lord, here, my lord, I have annexed the appointment order, my lord, of other person. My lord, kindly see page,
Appointment of other person?
my lord, 116.
That's the difference.
Yes.
Yes, let us see what is the clarification.
That says the selection and appointment are interchangeable. Lordship.
Huh?
Interchangeable. Word selection and appointment is interchangeable.
Who said?
Lordship, division honorable word.
Acha.
And in that case, my lord, it is a admitted fact, my lord, he was appointed. That.
Selection and appointment is interchangeable.
Yes, Lordship, that has been clarified. Lordship, page 7. The scheme of executive instruction and the materials available on record clearly postulate that respondent authority gave an advertisement for filling up the post of ground warden, and after conducting viva voce of the respondent number 4, has been appointed as ground Pradhan of so-and-so village under so-and-so revenue.
Yes.
The contention raised by the learned counsel for the appellants that it is not an appointment but selection runs contrary to the provision of executive instruction under 62A as same speaks appointment. Similarly, the provision of executive instruction 162B speaks the appeal against the appointment. Only because the word selection is used, same does not mean that no appeal would lie in as much as the word selection and appointment are interchangeable and thus alternative remedies available as provided under executive instruction 162B. That should be C logic, maybe typographical error. The provisions of executive instruction 162C provide second appeal and provisions of executive instruction 162D provide for review of the order of the commissioner. Thus, a full-fledged alternative remedy and machinery is provided by the executive instruction, and in such an event when appellants have an efficacious alternative remedy which is required to be exhausted before exercise extraordinary jurisdiction of this court under 226 of the Constitution of India, more particularly in the section of the present case. The contention raised by the learned counsel for the appellants are baseless and deserve to be negated. It cannot be said that learned single judge has misinterpreted the provisions of law and has wrongly applied executive instruction number 162.
But Mr. Counsel, when you come to the page before that, it speaks of the earlier 162C, not the amended 162C. Then-
Maybe typographical error.
What type of, what do you mean typographical error?
Very similar, page 4, let's see.
Page 4.
Yes, last para.
Ah.
Learned single judge dismissed the petition on the ground that an alternative remedy is available to the petitioner by way of filing appeal under executive instruction 162C. Before the divisional commissioner being aggrieved, the present appeal has been filed. That's it.
In that case, my lord, appointment was issued, my, on that circumstances, my lord, on that particular case. It was issued.
No, out it says, and the respondent number 4 came to be appointed as Gaon Pradhan. So that use of the word
Has been appointed.
as selection later on did not change the fact that he was appointed. If you look at the earlier paragraphs, look at paragraph 2. It further appears that the first page, second last paragraph, second last line. It further appears that the Viva Voice was held for the post of Gaon Pradhan for different places, and the respondent number 4 came to be appointed.
That is well, actually, in page 7, it is clarified that the word selection and appointment has been are interchangeable.
No, sorry. Okay. Came to be interchangeable in a way because of the wrong use of the word by the learned single judge. Because he was appointed, just because the learned single judge said selection, did not
No.
mean that,
Then
there was an appointment made. If you look at the first paragraph,
filling agreement, the first paragraph, filling agreement and dissatisfied with the judgment and order to change.
then those petitioners filed a writ petition saying that the respondent number 4 had been selected.
Which paragraph?
And look at what
Para four, page
para four.
4, the
Page
appealing hearing filed a petition under 26 to 26. Page 4, Lordship, just the
yes,
constitution of India containing the respondent number 4 who is selected to the said post has violated the criteria connected advertisement. And this, in the present, this is also selected, Lordship. This petitioner also selected, not appointed, Lordship.
that is the contention. Now you come to what the division bench has said in page 7. Page 7. Page 7.
Yes, sir.
The scheme of the
Just-
executive
yes.
instruction and the materials available on record clearly postulate that the respondent authority gave an advertisement for filling up the post of Gan Pradhan, and after conducting the Viva Voice, the respondent number 4 has been appointed.
Yes.
Then it says, the contention raised by the learned counsel for the appellant that it is not an appointment
Yes.
but a selection
Selection.
runs contrary to the provisions of executive instructions as the same speaks of appointment.
Hmm.
And now, why did it say this, the division bench? Because it was considering the unamended provisions.
The Lordship, no, that.
Ah.
Page 4, this is stated, Lordship. Learned
No, no, Mr. Counsel, please understand one thing. Please come to page 6.
Yes.
Please read 162C.
Okay.
Please. Please read 162C. I'm trying to make you understand. If you can't understand, I can't help it.
A second appeal from the order of Deputy Commissioner
Ah.
applied.
So you see, what the 162C that you are talking about and what the division bench was talking about is two different things. It's not the same thing.
But-
It unfortunately was considering the unamended 162, not the amended 162. It was in that context that this thing has been made.
If para 4 is, okay, page 4 is, if we
Okay, right. Heard, Mr.
SK. SK.
SK
Roy.
Roy, learned counsel for the petitioner. Also heard Miss M. Bhattacharjee, learned
2 to 6, Lordship.
counsel for the respondents number 2 to 6, Mr.
And S. Dr. Person number 1.
This is Mr. S. Datta for respondent number 1 and Mr. D. Bora for respondent number 8. Who is for 7? Mozadar.
Here,
Hmm.
from me.
Huh?
No, I'm not a bit.
Mozadar,
That has to be.
no one appears for the respondent number 7. Full stop. Right. No. Out here, 2, 3, 4, 5, 6, 7. Mr. J.K. Goswami, learned additional senior advocate. So, madam, you are for 2 to 7. Full stop. Right. The appointment of the respondent number 8 as a Gaon Pradhan is assailed in this writ petition on 3 grounds. Firstly, on the ground that the respondent number 8 was not a resident of the concerned village, that is Sanpara Parbat. Sanpara Parbat. SANPARBAT. Sanpara Parbat. So secondly, that the respondent number 8 was a member of a political party at the time of his selection as the
He's
Gaon,
also- He's also.
at the time of his selection, at the time of selection as the Gaon Pradhan by the state respondents. So thirdly, the petitioner, who was the son of the retired Gaon Pradhan, should have been awarded marks in terms of clause
Page 27. Page 27.
G of the advertisement dated 1/12/2021. The next paragraph, the petitioner's counsel submits that the petitioner and the respondent number 8 took part in the selection process for appointment to the post of Gaon Pradhan in respect of the village Sanpara Parbat, SANPARA pursuant to an advertisement dated 1/12/2021. The clauses, the terms and conditions in the advertisement dated 1/12/2021 stipulated that a candidate should be a permanent resident of the area in which he sought appointment to the post of Gaon Pradhan, and that preference would be given to family members of Gaon Pradhan, and the views of the Mozadar were to be taken into consideration. Further, a candidate was not to be a member of any political party. The petitioner's counsel submits that the petitioner, that the respondent number 8 was a member of the Bharatiya Janata Party, bracket BJP. And also a member of the which Gaon Panchayat, which Gaon Panchayat was that page?
'87.
And a member of the a member of 4 number constituency under 87 number Bongshar Panchayat. Page 43, huh?
He was elected as a.
Huh?
He was elected as a member of that, as a BJP candidate.
He submits that the respondent number 8 was elected as a member of the said panchayat as a BJP candidate. Further, as the petitioner was not given marks, any marks out of the 10 marks to be awarded to the family of a Gaon Panchayat member. And after,
Page 32 also.
and after taking the
Those other views. Page 32.
and after taking the views of the Mozadar, comma, as reflected. No, not as reflected, comma, which has been done in terms of the letter dated 21/12/2021 issued by Shri Dilip Bharali, DILIP, BHARALI, comma, Office of the Mauzadar, comma, PUB dash Bongshar, BONGSHAR, MOUZA. Page 32. He submits that in view of the above reasons, the selection of the respondent number 8 as Gan Panchayat of Sanpara Parbat being illegal and in violation of the terms and conditions laid down in the advertisement dated 1/12/2021, the said selection should be set aside. Pusta. Next paragraph. Actually, the said selection made in terms of which is the impugned letter.
And at page 38,
The said selection made
25/5/2020.
page 30
Page
made in terms of the notice dated 25/5/2022 issued by the Office of the Deputy Commissioner, Kamrup Amingaon should be set aside.
in respect of
Naturally, where? Next paragraph. Mr.
as the
S. Datta, learned
standing council.
Standing Council Revenue submits. Standing Council Revenue, bracket respond number 1, submits that an appeal can be submitted before the office of the where is that letter? Appeal can be submitted before the office of the Commissioner Secretary / Principal Secretary of the General Administration Department against the selection of the respondent number 8 as Gan Panchayat by the Deputy Commissioner, comma, in terms of Executive Instruction number 162, capital C of the Assam Land Revenue Regulation, comma, 1886, bracket amendment, bracket close, comma, 2018, herein referred to as the amended regulation, comma, 2018. He also submits that the question of application of the preferential clause to be given to family members of the Gaon Pradhan in terms of the advertisement dated 1/12/2021 can only be done if the marks obtained by 2 candidates were equal. As the petitioner had obtained less marks than the respondent number 8, the preferential clause could not be applied to the case of the petition. That's all.
I'm sorry, Lassit. To clarify the position of the redundant judgment.
Ah.
I-
He also
please-
submits that though the amended clause, executive instruction number 162C does not speak of. That does not, does not speak of the, does not refer to the word selection, invert comma, the selection, comma. The words invert commas selection and invert commas appointment are interchangeable. In terms of executive instruction number 162B, comma, as provided by the division bench of this court in its order dated 30/07/22, passed in WA 227/22, invert commas, Amia Kumar Kalita and 7 others versus the state of Assam and 3 others.
Clarify the position of the division bench as well.
Huh?
Single, to clarify the position of the division bench as well. But if can you see the single result, single result. The application number 3764. Lordship order.
I know, with my order.
Yes, President. J. Henry, Planning Council, for the respondent number.
I know, this is my order.
That 162C has been mentioned. Amended to. The other hand, the advertisement in the division of the advertisement was issued in the year 2021 and amended was made in 2018.
I'll not make more comment on that. Yeah. But that was, but then out here, it has referred to the unamended 162. Not to the amended 162.
Language it is, but if facts of the case is, if you see, advertisement was issued on 1/12/2021 and amended was a private.
Huh?
Amended was made 2018.
Just get that out. Next, anyway,
3764/2022.
Miss M. Bhattacharjee, the learned, Miss, before you right? And the counsel for the respondent number 1 thus praised that the writ petition should be dismissed, as the petitioner has an alternative remedy available by going in appeal under the amended executive instruction number 162C. Next, Miss M. Bhattacharjee, the learned counsel for the respondent number 2 to 7 also submits that as there is an alternative remedy available to the petitioner would have to exercise the alternative remedy by invoking the amended executive instruction number 162C. So stop. Next para. Mr. Yes, Mr. What's your name again? Debora. The learned counsel for the respondent number 8 submits that it appears that the appellant, that the petitioner has already availed of the alternative remedy by invoking the amended executive instruction 162C. As per the order dated, as can be seen from the order dated 5/4/2023, passed by the Commissioner, Lower Assam Division, Guwahati, in case number RR 22/2022. Full stop. The said order dated 5/4/2023, passed by the Commissioner, shows that the case of the petitioner has been dropped, that the appeal of the petitioner has been dropped, and as such, the present writ petition should be dismissed. Full stop. He also submits that as per the letter dated 29/12/2021, issued by the Mouzadar, Mouzadar, Pub Bongshar Muza, Swalkuchi, page 101. The respondent number 8 has been certified to be a permanent resident of Sanpara Parbat village. He also submits that as per the letter dated 29/11/21, issued by the President, number 87, Bangshar Gan Panchayat, page 106. The respondent number 8 had submitted an application on 29/11/2021, seeking resignation from his membership from ward number 4 of number 87, Bangshar Gan Panchayat. He thus submits that the petitioner, being a resident of Sanpara village, Sanpara Parbat, and having resigned from his membership of the Gan Panchayat, the petitioner could not, the respondent number 8, could not be said to be a member of any political party. Full stop. Full stop. He also submits that there being an alternative remedy available, the petitioner has to avail of the said remedy. And in support of his submission, he has relied upon the judgment of the apex court in the case of Commissioner of Income Tax and others versus Chabil Das Agarwal, 2014, 1 SEC 603. I'll give to the scenes there, no? Did you right? He accordingly submits that the writ petition should be dismissed. Wait, just one more thing. I have heard the learned causes for the parties. Just put that. And it is right. It is right. So. Hearing concluded, judgment reserved. Let me think.
14 judgment I have referred.
Huh?
14 judgment I have referred.
Oh, you have referred. Okay, the 2014 judgment, put it in respondent number, also for respondent number 1, the last judgment. Yeah?
Stated that he also resigned from the political party. I have the document to that effect.
No, that is not in the report, sorry, not now. It's too late now. You cannot add things as you go along. That type of documents even I can bring. Tomorrow I can also resign from a political party. Or you can get documents from the government. I can also get documents from the government. But that is not an issue now. I mean, in a way, the disputed questions of fact.
Actually, that,
But,
Yeah. actually, that's why everybody wants to go to the appeal. Because
they will bring
the
those documents.
constituency is also the honorable CM's constituency.
Anyway, what to do?
I have also.
Huh? No,
Online.
big problem. He's hitting me with my own order. Anyway, let's see.
May it please your lordship.
Yes,
Lordship, we are led by Mr. UK and I am my lord. However, due to some difficulty, he had to leave the court. My lord, can it be fixed up next Tuesday, man?
Thursday. We
Thursday-
are fixing too many cases in Tuesdays and Wednesdays. No dates.
My lord, there's an urgency in this matter.
Mr. Counsel, all cases of all the senior counsels are urgent. Tell me which case is not urgent? Right. On the prayer for adjournment made on behalf of Mr. UK, this is the matter after 10 days.
My pleasure, Lordship. I'm party petitioner here. Now, on the last occasion, Lordship had granted one last opportunity to the respondents to file their affidavits. So. In fact,
Lordship, it's ready, Lordship. We'll be filing within 2 days.
When
Oh, inspection is already here, Lordship.
instruction is here, when will you
Yes,
file?
Lordship.
Then if, when
Within
you make
this week,
the,
Lordship will be fine.
when you make the affidavit, has it to be sent for vetting? No, not required,
That's not necessary.
not required.
It can be done online also, Lordship, by sending the.
This is what is the matter about?
Lordship, this is the post of the in charge director of the Directorate of Geology and Mining, which has been vacant since 2017, my lord. Now, the Directorate has its own cadres. They have their own orders for promotion.
Own rules.
Yes. Now, my lord, despite that, what they have been doing is they are bringing in bureaucrats, ACS officers, now in the instant case, Indian Forest Service officials, and they are being posted as in charge directors. So the claim of the writ petitioner, who apparently is the senior most incumbent.
Who is supposed to be promoted to the, how is the post of director to be filled?
Now, there's a
What does the rule say?
rule say that anyone who holds the post of the chief drilling engineer or any other post, which is specified.
Show me the rule.
If I appear on behalf of Mr. Yukina for the respondent number 3, we need to file an affidavit in this matter.
You are not filing, why should we wait? You don't want to file, don't file. In some cases, yes, everything is so urgent, in some cases not urgent. Yes, so show me the rule.
Today in the morning, we received the instruction. Today in the morning, we received the instruction. I will be given one, let it be after a week, no, by the time I'll file it.
He said she'll file it within 2 days and you're saying 1 week. Okay, within this week.
Got
Within this week. So she said within this week means 3 days.
Let it be,
And then you want a week. But this, you're.
let this be listed after a week.
No, why should,
It will
why,
be fine.
if you're going to, why should it be listed after a week? Why not within a week?
Well,
If she's willing to file.
Got
Unless you're not willing to file.
no, we'll file. Today in the morning I have to.
Yes, what about you?
We'll also file.
When? Within this week? What does the rule say anyway?
As per the existing service orders, Lordship, the writ petitioner is apparently the senior most incumbent.
No, I'm not saying that.
Yes.
Is it a post, IAS post, is
No,
it a ACS post,
It's from the.
departmental post,
Yes, Lordship.
departmental officers post?
Departmental post. It is a departmental post. They have their own service orders. The petitioner is the senior most. Now the post has been lying vacant since.
Have you got any judgments in your favor?
No, the rules make it apparent, Lordship.
There is a,
There are some judgments. What do you mean?
there is a development in
It
this.
is, yes.
There is a development in this case. In fact, the matter went to before the division bench. The honorable division bench has passed an order. Well, we have prepared a review petition seeking a leave so that the government can proceed with amendment of the rules. Now the government wants that the department, the head of the director is to be meant by ACS or IS officer. So that review petition is pending. Lordship, will this time will in the affidavit will bring the development also. That instruction.
That's okay, but
Instruction
just
I have
to bring
received.
it,
So it is not a case that just the rule is there and nothing, no
No,
development.
you
is
see,
there.
but till a new rule is made,
yes, Lordship.
if there is a valid rule pending,
But that is one part and the decision of the government, Malad, decision of the government is also there. We will place logical consider.
Lordship, just to submit, my lord, they have gone for a review. At the same time, the petitioner herein has also filed a contempt.
Though both are pending.
And on
taken-
7/8, the honorable division bench had passed this order in the contempt, which Lordship may just have a look.
Gotcha.
2 weeks time granted to the respondents to complete the process, or they will be called for personally called to the court. But the matter has not been listed as yet. Lordship. This is the contempt filed by the same petitioner before the division.
why have you filed this case?
This is a different issue because the matter went up
now
to the
what-
division.
What is this matter about?
This is the division bench had passed an order in 2022 directing the respondents to complete the process of selection for promotion to the post of director within a specific time. That was not done, so we filed this contempt. In the meantime, they also filed a review petition, which has not been as yet been.
Is
given.
the division bench order here?
This is there, it is there. And thereafter, Lordship, when we filed this writ petition, matter went up to the division bench. But then division bench again said that this has to be taken care of by the single bench. So it came back again.
Where is the division bench order?
Yes, Lordship.
At page 65.
Lordship, page 63, annexure 9, it starts.
Ah,
Malad, after passing of this, Malad, we have prepared the review petition. The review is pending before the court.
whatever, that is a different thing.
Malad,
Review
now-
is pending doesn't change the fact
Correct, Malad,
that as on date, you still have to comply with the order.
Malad, page 73 is the order by which the additional charge has been given. No promotion, the regular promotion has been given. The order impugned here. At page 70.
Yes, Mr. Yukenar.
My lord,
I'm for the person who is now being allowed by the government to hold the charge. One of the whole grievance is based on a service. of- The draft rules are underway, it is being done. Now, the government took this decision, I'm a forest officer, I'm an IFS officer. They saw my capacity is there to do it, and I have been doing, my affidavit is ready, my lord, what works we have been doing after my joining, I'm bringing it before my lord. If nothing was moving in the department. my lord.
You see, that is not the concern of this court.
No, my lord. My lord's concern is with regard to the orders passed by the.
We
division.
are only concerned with the question whether the valid rules as on today are being implemented or not. That's all.
That's all. But the orders, there's no
Whether you are
rules, my-
doing a very good job or bad job, that is not
No,
our
no, that's
concern.
all. My lord, the orders, there is no rules still now, my lord. No rules have come into being till now. The rules are in the pipeline only, my lord.
Then he's
It's
saying that.
it's an executive instruction, my lord, before your
Instruction that
lordship.
is being followed since
So-
98.
It's an
Anyway,
executive instruction, my lord.
so-
So the government has, my lord,
That is
when
not
it's a
for him
161
to,
But till that new rules come into play,
lordship.
yes.
then the
The
executive
government
And that
instructions
is
have
not
to be
for
taken.
taken a policy
respondent
decision
free
to
to
that
argue. That is not his
They
point
have,
at
my
all.
lord, they have to bring that before your lordship
He
as to
is
why they have done it.
Joint,
Okay, when will you file it? When you file it?
he's holding
This,
joint
but
additional post.
Just a minute.
He has no
Just a minute.
lordship. Let the
My lord
government
can-
come
No,
up.
just a minute, everybody, please. Otherwise, I'll have to take my BP medicine before time. I take it every evening. Please don't,
My lord.
you have to think of my BP also. Not only.
My
yours.
BP, I came running, my lord. My lord,
Anyway,
have it on-
when will you file your,
my lord, I'll file it within by the last week, my lord, surely.
what do you buy the
No,
law?
no, September, today we are on 18.
No, too late.
So long.
No, my lord, Ajit,
You already.
my lord, I'm saying next week, my lord.
No, your junior said
Huh.
that he'll file it by this week. Now, why are you saying?
But I'll file it by Friday, my lord. Friday, no problem. They file it now, they know it better. my lord.
Yes.
And let him also prove his.
I don't know
qualifications,
why,
technical
even
qualifications.
when Mr. Deenath came, he wanted 1 week. While Ms. M. Bhattacharya said she'll file it within 3 days. Or this week, by this week. I don't know
My
why
lord, have it.
why the seniors are,
My lord,
taking more time.
My lord, they
You
know
are
it better.
supposed to be the ones who are, more helpful to the court or understand the court better.
We'll assist your lordship, my lord. My lord will have it next Wednesday. By Friday, I'll file my affidavit. my lord.
Right.
Let it be on Thursday next month. if
Thursday,
lordship
fine,
will-
my lord, fine.
Anyway, let them file it by
Yes,
this
yes.
week.
Let
I'll
him-
file it by, my lord, Friday. I'll file.
Correct.
Good.
Mr. Deenath, learned counsel for the state respondents, and Mr. UK Nair, learned senior counsel for the private respondent, submit that they will file affidavits in a position positively within this week,
Friday.
within this week, accordingly. And list this matter on Thursday.
20th. Next, much of it.
I don't know what step the respondent number 3 is taking. He is merely an appointee.
No, let him file.
Yes, let him file for his.
He's a,
satisfaction
you see, then,
And show
you
how
see-
much technical ability
No,
he
no,
has to
no,
run the
no,
department.
Mr. Counsel,
Let us see,
one thing you've got to
My lord.
understand,
lordship.
if he was not a necessary party, you would not have made him a respondent. Since you have made him, let's give him a chance to
Yes, yes,
explain.
it's all right, but
I was invited here.
they have dragged it on for more than a month despite orders. Obliged, lordship.
Best result. The long back, Lordship has heard this matter, almost finished. And Lordship has written down the facts and also the submissions. Illustrated. Here, Lordship may recollect. This is a case of attempt to recover the salary paid to the petitioner who has been retired from service on the ground that he served in excess for 1 year. And from the date of his actual retirement. That's the case. If I may take your lordships to the order lordship has already recorded on 11/8/2022. It will refresh our memories, my lord. Should I place it, my lord? Okay. Yes.
Heard Mr. So-and-so, so-and-so. Petition two, the petitioners are aggrieved by the order dated 14/6/2017, by which an amount of rupees 23,97,895.
Okay, so that is for recovery because of 1 year.
Yeah,
Excess.
excess service. Yes, rendered. They say that I ought to have retired in November, February
2016.
2016. I retired in
17.
17. They want to recover that period. Their allegation is that there was some interpolation in the date of birth.
Since you were looking after the service record
Since
to-
I am the beneficiary of that, then
and you are the beneficiary of that,
they want to say.
so you were the one who had.
I am the culprit who has done it.
Yes.
That is the only thing, but there was no finding, nothing. There was no inquiry. They could not do it. The fact remains that the attempt made to initiate an inquiry just after my retirement was subsequently dropped by them, and this honorable court in the appeal therefore disposed of the appeal on that count. Lordship has recorded it.
The appeal, what appeal?
Appeal in this, my lord, when they issued a notice for inquiry.
That you are
I
challenged
approached
that.
this honorable court. This honorable court, the learned single just said that they don't recover, but you submit to the inquiry. I said, no, I went to the appellate court. Appellate court said, before saying something, they came up, said that we are withdrawing because there is no provision. There is no provision to proceed against the workman who has meanwhile retired. Therefore, they made the submission that we are withdrawing the proceedings, no inquiry.
Petitioner's has been expired when?
Petitioner has expired.
Petitioner's husband.
Sorry, yes, petitioner's husband has expired. We have substituted, no? During the pendency. You can come to a substitution petition. What goes it? You can come my substitution petition. Application for substitution. Just a minute, my lordship will give me 2 minutes more time. There's no corner, I have to- something. This certificate of funding. This one I got to do. Substitution petition of public domain. Yeah.
Have you brought citations?
Yes.
Wait, then you just give me citation. Which one? Rafiq Masi,
They have relied on this.
Chandi Prasad,
Yes, my lord.
then the Pakistan Cooperative Society
Yes.
and Rantu Kumar.
These were the citations they made.
And I think you have got Thomas Daniel, you are relying on Thomas Daniel, 22, no?
In these decisions, my lord, that we are relying on, my lord, the principles regarding recovery has been, my lord, laid down and what are the exceptions. I'll, my lord, give the paragraphs also, then it will be conducted.
Yeah, just let him complete. Rafiq Masi.
Let the death is coming, my lord. It is, I have not been able to look at it immediately.
The death of the petitioner
Yes,
husband.
Husband's death. That, only if I may take a losses filed in the substitution petition, IA. It should be there.
Aye.
Substitution petition.
Yes.
There, my lord, the date of his death. Let me find it there.
Acha, in the IA.
Yes.
He's not dead or what?
Sorry.
There's nothing to show that he has died.
Yes, died, my lord.
The petitioner is Jatin Chandra Sonowan. On the death of Jatin Chandra Sonowan.
Yes. My lord, IA number
16/10/2021.
1610.
Yeah.
Yes, 1610.
16/10/2021.
21.
1610/21.
Yes, that annexure eight.
I
Sorry, at page eight.
See, this is not 1610. IA.
IA number,
IA.
IA number 2079. 2079 of the program is 21. Page number 5.
Sixteen, 2020.
Thereafter, legally after substituted. My lord,
Yes.
so here, the question is that when I submitted my date of birth, there is no dispute that that was the correct date of birth I submitted. It is,
What was the date of birth recorded?
date of birth recorded is
Lordship has noted it in your Lordship's order. It is
1956.
1/3/1956. 1/3/1956. But in the thereafter, immediately when I was issued my identity cards and other records, there they have shown my date of birth as 1/3/1957. And that remained. That remained all through. They ultimately issued me the notice for retirement. Kindly see. Notice of retirement was issued to me
February 2017.
No, my lord. 21/9/2016, the notice was issued to me.
Page?
Page 25, Annex 5.
Yes.
This is dated 21/9/2016, right hand column top. It was addressed to me and I'm placing it, my lord. Retirement. We write this to inform you that as per our record, you will reach the age of 60 years on 28/2/2017. And you note this. As you are aware, the superannuation age of an employee of company has been fixed at 60 years. And accordingly, as per company's rules, you will be due for retirement for the company's services after close of working hours on 28/2/2017. On retirement, you shall be eligible for retirement benefits in accordance with the rules of the company. We would advise you to contact the officer in charge of the superannuation and wages section of the company's finance and accounts department at least 3 months before the due date of your retirement for carrying out the formalities. We are enclosing a set of forms which are to be filled up and submitted by you. We would also like to inform you that the company has a scheme for extending medical facilities to retired employees. You are required to deposit one-time payment of rupees such and such towards subscription fee for availing the facilities of post-retirement medical benefits scheme. Thereafter, you and your spouse will be entitled to medical benefits to the extent available under the scheme. The application format for availing medical benefits is enclosed. Please fill up the same and submit to medical section of employees relation department. The one-time subscription amount can be deducted from your salary. On receipt of the authorization undertaken to do so. If you do not submit the authorization undertaking before your retirement, you will have to submit the said subscription fee by demand draft payable to Oil India Limited, Duliajan. In case we do not receive your application within the stipulated time period of 3 months from the date of your retirement, it would be presumed that you are not interested to subscribe to the above medical benefit scheme, and subsequent request in this regard will not be entertained. A copy of the scheme showing its salient features is enclosed for your information and record. As per the existing housing rules, you shall be required to vacate the company's quarter presently occupied by you within 3 months of your retirement. Therefore, we would request you to make necessary arrangements for vacating the quarter SAP on your superannuation, failing which we shall have no option but to charge you rent at the rate of 5,000 and 6,000 respectively, 7,000. These are the categories per month, in addition to initiation of other legal actions as per the rules of the company. In case you need any assistance in filling up the forms, please contact the concerned executive help desk
so and so. We may take this opportunity to express our deep appreciation for the services rendered by you and wish you and your family a very happy and prosperous life ahead. This is the notice of superannuation given to me. Thereafter, I filled up my forms. All have been given. Next page, Lordship will see. This is also form of final settlement on retirement. This is was forwarded to me. We are forwarding here with the retirement notice as referred above against your employee who is retiring on 28/2/2017. Also, we are forwarding here with both the application form at Annexure 1 and Annexure 2 in connection with post-retirement medical benefit scheme. You are kindly requested to hand over the same to the concerned employee and advise him to submit both the formats after filling up and signing. All that is there, my lord. So thereafter, kindly see, my lord. This is dated 27/10/2016, and after almost nearly 2 months, Annexure 7, I got this promotion. Annexure 7, Lordship may kindly come to page 27. This is subject promotion on stagnation relief. It was addressed to me. We are glad to inform you that as per amended promotion policy on satisfactory completion of specified span period in your present grade EG1, you have been promoted to the job grade EG2, grade code E2, with new designation as supervising assistant as per details given below. Effective date 6/12/2016. New grade on promotion, grade EG2, new basic, new protected personal pay, new special increment pay. So that is my promotion just before my retirement.
Page,
Page 27.
come to this affidavit of the Oil India
Yes,
at page 58.
my lord.
Otherwise, separately it will be page 16.
All India.
Page 16. Annexure R1
R1,
at the bottom, date of birth.
date of birth, 1/3/1956, 1st March 1956. That was as per my documents. So it is not the case that I conceal my date of birth, actually date of birth. I have given my real date of birth. But it is they who calculated date of birth means, my lord, it was they calculated out. My certificate only says about the age. Age. They calculated out date of birth, they entered this date of birth, and they mentioned it date of birth in all my documents as 57. That continued for the entire period of my service. For the entire period of my service, they never pointed out, they never took it that there was a wrong calculation done on our part. That was wrong. So here it is not a case that I wanted correction of my date of birth or that a false date was given earlier. It is not. All the time, this is my consistent plea that I have given you. But it is you who recorded something else. Or if there was manipulation, who has done it? I am a workman. I do not have access to the documents. as those documents are maintained by you, personal department, and the top secret. These are securely kept by them.
Okay, now let me hear the other side.
So therefore, my lord, let me just finish on the factual ground and on the law point.
No, no, the facts are clear.
Yes,
And I think you're going to Rafiq Masi's case.
Rafiq Masih's case, I have also some more cases, I am just pressing it. Kindly see,
Because I think the facts are quite clear.
facts are
There-
quite
There's
clear.
nothing much to
was no-
say.
There was no any inquiry, nothing of the sort. They say that it is presumed. It is presumed that since you are the beneficiary, you have done it. But that presumption will not come in here. Rather, they will be stopped under 115 of the Evidence Act. That you having taken yourself and allowing me to continue with those records where you have mentioned yourself that my date of birth is 57. You are stopped now after this distance of time to deny me the benefits. Throwing the blame on me that it is me none other than who might have.
Okay, let us go to the citations.
So, my lord, that being the position, kindly see, one thing, my lord, should I just mention? I think it should be mentioned because on the last occasion when the case was heard, Lordship has recorded the order. That day, the submissions were made by the learned senior counsel, unfortunately, who is not amongst us today, that I am holding the executive post. Lordship may recollect. So I need a clarification.
No,
Yes.
no, I think he has clarified it also. That you are a workman, grade 9,
I am a workman. All throughout
Great
that you are.
but you are getting the pay of an executive grade 1 officer.
Exactly. Well, that is not an executive grade. This is the job, grade of the job. That is what I pointed out, page 27. They have mentioned it by provisional order. Lordship, they have said, you have been promoted to the job, not a post. It is a job, my
Where?
job,
Page,
page 27. Annex 7.
anyway, the fact remains that actually your date of birth is 56.
Yes.
So you should have retired in 2016.
60.
Now, assuming, so tentatively, in terms of Rafiq Masih, the money should not be recovered. But then your pay, as on 2016 February, that should be the ground for, that should be the basis
For
for your
calculation.
pension.
Well, I do not have any objection to that. I do not have any objection. Rather, this is the law laid down by this.
So your promotion also will go.
My promotion cannot go on.
The promotion will go because you were promoted after after February 2016. You were promoted sometime in November, December.
No, in December 2016.
So that's fine. But you should have retired in March, in February
In
2016.
last date of the February 2016.
That's why that cannot come. That
Now,
will go.
now, Malad, my responsibility will be,
You
yeah.
cannot have your cake and eat it 2 times.
Malad, yeah. This is apparently recovery cannot be made.
Recovery, okay,
Of
we
that
do it.
promotional
recovery.
grade also,
Ah.
no recovery. Regarding
Promotion,
fixation of my
seniority,
benefits.
As per February
February
2016.
2016. That is the law, and that probably I cannot claim other part.
Correct.
But so far recovery is concerned, that they cannot do it. They cannot do it because I have no guilt on that. I have not done anything wrong so that they will penalize me, and there was no inquiry, nothing of the sort also. And therefore, well, one decision in that, exactly on that line, Lordship has just mentioned, that decision 2009 3 SCC 117. It makes the whole text clear on that point. And to copy it as a name.
What is that? Verma's case or something?
Well, this is State of Bihar versus Pandey Jagadish Prasad. 2009 3 SCC 117.
Para?
Para my lord, I will place para 15, 16, 17, 18, 19, 20, all these cases have been discussed.
What about this thing? What about the case of Thomas Daniel?
Thomas Daniel,
Give me the citation, 2022.
lastly, 29. Thomas Daniel, case 20.
Thomas Dan, 22 SEC online, SC,
Yes.
536. Give me a copy.
2022 and
That is a citation you are relying upon.
cannot be done from the employee on being class 3 and class 4 category employees.
That is Rafiq Masi.
Thomas Daniel also,
Yeah.
my lord. Thomas Daniel.
You don't have that.
Paragraph 9 from onwards.
Extra copy you don't have. Only for you.
Sorry, my lord, probably it was earlier, lordship may find
It's not there. It's not there.
that was placed on the last occasion, that time.
So which paragraph?
From paragraph 9. This court has, the Honorable Supreme Court has discussed the principles. Paragraph 9, 10, 11, all these cases have been discussed. It starts like this court in a katana of decisions has consistently held that if the excess amount was not paid on account of any misrepresentation or fraud by the employee, or if such excess payment was made by the employer by applying a wrong principle of calculating the pay allowances or on the basis of particular interpretation of rule, order, which is subsequently found to be erroneous, such excess payment of emoluments of allowances are not recoverable. The relief against the recovery is granted not because of any right of the employee, but in equity exercised in judicial discretion to provide relief to the employee of the
Okay.
hardship. That will be,
Okay,
Cause-
Mr. Manta, I think that's.
yes, that is the principle. That is the crux, and that is has been written.
Let us hear Mr. Chowdhury now.
Yes. So in that decision, I have just placed my lord. Same thing has been repeated by analyzing all the decisions of the appellate court.
Yes, Mr. Chowdhury.
I'll draw your lordship attention to only two more documents, my lord. If your lordship kindly takes up our affidavit in opposition.
Page.
The first, my lord, that your lordship has already seen in the requisition, your lordship will find that page 58.
Page
58 of the affidavit in opposition.
58.
That is employees biodata.
58.
My lord, whether the designation is correct or. Annexer R1, Annexer R1.
Yes.
Now, your lordship has seen. The date of birth has been, my lord, entered as 1/3/1956.
Yes.
Then his signature is there, my lord.
Correct.
This is not disputed.
So
Then your lordship may kindly come to page 78.
page 78. Yes.
Your lordship will find, my lord, this is a register of employees. And the petitioner's name, I mean, this is petitioner, year of birth, 1/3/1957, and clearly, my lord, there is a override. And now the question that arises, my lord, who is the beneficiary of this, my lord, overriding?
No, that is okay.
Any other person, except the petitioner, will be benefited out of this.
No, that is okay. But then the fact remains
Yes.
that to really pinpoint the culprit, you were supposed to have an inquiry done. And you had in fact started it.
Then it has been, my lord. That's right, my lord. I will not dispute that on fact,
Now, if you have not carried on with the inquiry,
that he is the person who is guilty for
now
that.
can you say that he's the person who did it?
The only, my lord, the necessary corollary is that, my lord, he is the only person who can be benefited by this.
No, that may be, no doubt. Benefit that way, so, but then the Supreme Court has held in so many cases. Unless there is a fraud or misrepresentation. And for that fraud and misrepresentation, there has to be an inquiry and
That's
that
the
has to
first.
be,
That is not there. my
that is not there.
lord. That is
So
not there.
in that case, I think, I don't think you can recover. Only thing is that his pay should be given as per February 2016, wherein his promotion will go.
My lord, will abide by whatever. policy
That is the only way.
shared. Yes.
So I understand your logic. It's
Yes.
very correct. But then what to do? The Supreme Court in one case has also said very clearly that there has to be an inquiry to find out who is the culprit.
That's right.
And
But then, my lord, these three decisions that I am referring to, my lord, your lordship, may kindly peruse, my lord,
Yes, yes,
these, my lord, the.
yes, yes. I will peruse. Please give me.
I'll give the copies. my lord.
What's that this one? Okay, now let us go to that. Oh, yeah, you will. One minute.
Regarding the maintenance of the records, I have given their own document in my affidavit in reply. There, it is that their custody, the documents are not in my custody, documents are retained by them. This lottery board, but then since
I-
they are saying,
Oh, you two know best. I don't know.
I am the beneficiary. they
You
want-
all are the ones in custody. I don't know.
Had there been an inquiry, all these things would have come, that who maintains it, who did the fraud, if any, at all done by anybody.
Okay, so I will, okay, just say, heard Mr. K.K. Mahanta, Learned Senior Counsel, assisted by Mr. K.M. Mahanta. Also heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. K. Kalita for the Oil India Limited. Hearing concluded, judgment reserved.
My lord, may I indicate the paragraphs, my lord, all the judgments, so that your lordship, my lord, does not.
I've already, yeah, I think, recorded.
My,
I think Rafiq Masi 7 to 12,
yes, my lord.
Chandi Prasad is 7 to 16.
16 is the, my lord, main paragraph.
I mean, then cooperative societies is 7 to 11.
Yes, sir.
Then
Nine,
Rantu
my
Kumar is which para? 9. Rantu Kumar, 2021 5 GLT.
My lord, the paragraph.
My lord, I have gone through all these decisions, I may just tell your lordship, that those decisions have no application in my case. I can point out, given the time, my lord, I can point out, I have gone through each and every one, even that GLT decision, it is factually completely different. Doesn't fit in our case.
Anyway,
And other cases also.
but the problem, Mr. Counsel, is that I have to go through it again.
Yeah, but that is why I'm indicating, my lord. I am not taking your lordship right now,
Ah.
but if your lordship, when lordship will go through, kindly see that the law laid down what we have already discussed, that is the only.
Okay.
And my lord, the amounts which have been withheld should be paid to me, my lord, after these 5 years with interest.
Interest.
Person has died, my lord, suffering this on this tension.
Public.
Person has done. True, but I have also rendered my service. Not that I am claiming without any service. That is why I am claiming. I have rendered, they have taken my service, I have rendered my service. That part should be paid to the.
I want this book. I want this book. I wish I could dictate here, but lunch. Otherwise, again, it'll take time. Okay. Send it here, huh?
Highly obliged.
This is
Obliged.
here. Okay. Item? Which item? So you want to do what? Huh?
Will be mentioned on my behalf.
when it comes up. So what we can get.
Okay, you want to adjourn it or you want to pass over for the time being or what do you want?
Time being.
No problem.
Reconstruct the file and come.
Why don't you take it from your earlier council?
They have not provided us the same.
What is to be done?
Cannot object to it, my lord, but my humble, my lord, it may be fixed on a early date.
That we can do, but then they don't have a copy. Who is going to provide them copies of the petition?
If only the repetition is required, I may provide.
You ask your client to provide you.
We have not received any instruction from ASTC. We
From
coordinated
ASTC?
yesterday. My senior actually coordinated.
Huh?
My senior actually coordinated with the legal officer of ASTC, but we have not.
So,
received-
has your senior submitted his Wakalatnama?
Yeah, because
Submitted?
maybe, yes, that's why I'm not sure.
Who is this? What is your senior's name?
Timoy Roy.
Not here.
My lord, there is a designated senior.
Huh?
There is a designated senior, my lord, so possibly no Lokalatnama is there. Some junior will file Lokalatnama.
Oh, he cannot.
Yes.
In fact, you should not be saying all this also. He cannot meet directly with clients. That will be through you. Or through some non-senior counsels.
So your lordship, I'm here for respondent number 1 on behalf of Ms. MD Vora, standing counsel for transport department. Our new, if your lordship may please, our name
Miss MD Bora.
MD Vora.
MD Bora.
Also, if your lordship may please reflect our name on the positive.
And you are for respondent number?
2 to 6.
Miss
Nilufar Ahmed.
Nilufar Ahmed submits that she will be appearing for respondents number 2 to 6, along with her senior, Mr. J. Roy.
Yeah.
She however submits that she has not been furnished copies of the writ petition and affidavit, another affidavit by the earlier council. She accordingly pays for time to obtain the same. Good stuff. You, I don't know how you apply to the High Court or you ask the petitioner. That though is not our concern. Mr.
Shailesh Bora.
Shailesh Bora.
ZH.
Z, huh?
ZH.
ZH Bora. Submits that. They are not, that her senior, that is senior, Miss MD Bora, appearing for the respondent number 1. Is not ready with the case, come in as much as SC transport is not reflected in the cause list. The transport, SC transport is not reflected in the cause list. Mr. C. Chowdhury, senior counsel, appears for the petitioner. On the prayer made for adjournment by the respondents, list this matter after.
After puja, after this.
Why? He's in a hurry. There 2012 matter, madam. This matter after 2 weeks. After 2 weeks.
Okay, let me say, my lord.
Huh?
In first week of October, my lord.
2 weeks.
I'll be away from Guwahati.
You'll be away from when?
Up to 26th or 7th,
You'll be away from which date?
from 22nd
Of this month.
of this month.
Oh, you'll be away from 22nd of this month till
27th or 8th.
till 27th of this month. So 2 weeks means next month. Let this matter after 2 weeks. The registry to reflect SC transport in the cause list. I don't know, I don't know how you're going to, you please beg, borrow and steal from the petitioner. Okay. Obliged.
The matter may be taken up next week, matter, any day.
What is the matter about?
Promotion and petitioner promoted, my lord, senior assistant, my lord. Subsequent,
Petitioner promoted when?
my lord, 2012, my lord.
What is the matter about?
My lord, next week, my lord, any date, my lord. I have to take some instruction from the client.
On the prayer for adjournment made by Mr.
AM Ahmed.
A-
A Mutin.
Huh?
Here is A Mutin, A Christoph MATIN.
That much I know, but what is your name?
Abdul Mutin Ahmed, full name.
On the prayer for adjournment made by Mr. A. Matin, A. M. Ahmed,
Yes.
Leonard Counsel for the petitioner. This is the matter in the next week.
Purpose. Item number 18, my lord, I am appearing, my lord. My lord, I had misplaced the brief, my lord, and also lost contact with the client, my lord, and also don't know what is the current status, my lord. And gone through the file, my lord, started, my lord, contestation.
Look. Termination of petitioner is in 2012,
Contextual.
contractual. This is 2023. 11 years have passed.
Whether that engagement is still continuing or
Huh?
not. Whether that engagement. whether
No,
it's
there,
continuing or not,
no,
I
no,
don't-
there is no stay order. Where is the question of engagement still continuing?
No, they can be taken up next week.
Mr. S. Hawk appears for the petitioner and prays for time to obtain instructions in the matter. Full stop. The prayer of the petitioner is to set aside the impugned order dated 1/12/2012, by which the petitioner's service on contractual basis has been terminated. List the matter on, give next Monday, give a date.
Monday, Tuesday.
Monday. You just
Yes.
contact mobile. You just find out whether he wants to press the matter with 2012.
Yes, yes.
You see, because
Yeah.
now, you see, when
Probably, well, because since I have lost contact, well, the petitioner also did not contact me. Well.
probably he's not interested, also you're not interested. also.
Okay.
And anyway, you see,
I think nothing survive also. Right?
I don't think the KM Horoy's case is there.
Yes, yes. And moreover, contextual engagement. Right?
Then what to do?
Let's, and then Monday,
You withdraw with liberty to file a fresh.
yes, that's right.
I think that's better. I think.
That's better.
Na?
If anything
If
survive.
anything survives then, because I don't think
Yes,
anything
yes.
survives now,
Yes, yes.
2012.
Yeah.
Right. Heard Mr. S. Hawk, Leonard Counsel for the petitioner who submits that. Are you the counsel, by the way?
Yes, yes.
Who submits that he may be allowed to withdraw the writ petition with liberty to file a fresh. Full stop.
Right.
Prayers allowed. Writ petition is dismissed as withdrawn, come out with liberty as well.
18 only. Right?
Huh?
18, I'm.
Only 18, item 18.
And 19, I don't know whether 19 is connected matter. Whether it's not-
19 you give me. Let me see what is the prayer.
19 is also. I have gone through. Little bit.
19,
Some is- That also is contextual engagement.
'29, 11, 2012.
And it pertains to.
Contract, again, termination.
It is pertains to Gwalpara district.
And mine one was in department to Kasat. But under the same department.
No, he belongs to Rangya. I don't know, wait, huh?
Golpara district.
Golpara district, correct. Two 2012 he is terminated. I don't think there's anything left.
Repeatedly give methods. I don't know. Have consistent never shown me this position.
Last time this case was listed,
13.
2013. How come? What's happened? Huh?
I am also feeling sorry, madam. Still, I could not apply the code also, madam. It's not pending since 2013, madam. 10 years.
It has come up after
13.
10 years.
10.
Let me see. No point keeping it pending if no one is coming out. A. Chowdhury, Learned Counsel for the petitioner. Any idea who is A. Chowdhury?
No idea. Yes.
A. Maybe not interested also in
Okay.
pursuing, probably. Let me read. Yes,
Chief, here I am appearing on behalf of the health department.
in
But the-
item 18.
1890. Yes, Lordship, but the matter pertains to a National Health Mission, Lordship.
Huh?
National Health Mission, Lordship.
So,
It pertains-
are you the counsel there?
No, Lordship, the
Then-
name has not been reflected, Lordship.
Anyway, he has withdrawn.
Okay.
Since you are not the counsel, how does it matter?
I am appearing on behalf of the respondent number 1,
Okay, then in that case, you write Mr.
the Upaman.
D. Upamanu appears for point number 1. Huh? In
Yes,
that
yes,
item 18. Item 19. This is also 2012. He has been terminated.
Yes, Lordship.
And the problem is, this matter has been listed after 10 years.
16.
10 years.
10.
What 2016? After
13,
2013 is the last order.
in item 9.
In item 19, both.
Both.
How come it got stuck like this?
They should have mentioned,
Huh? Very surprising.
petitioner should have made a mention.
Huh?
The petitioner should have made a mention for listing.
Ah, right. No point keeping it any longer. I don't think. Right. No one appears for the petitioner on call. The matter pertains to the termination of the service of the petitioner who has been appointed on contract basis, comma, while order dated 29/11/2020. As the petitioner does not appear to be interested in pursuing the matter, the writ petition is dismissed for non-prosecution. Acha, you put Mr. D when you appear for the
Health and family welfare.
health and family welfare.
Highly object.
That was-
And may I please your lordship?
Yes,
I may allow you some time so that I can take instruction whether the petitioner is going to pursue the case or not.
huh? Whether,
He is continuing the case or not.
why don't you go and call him now? He must be having mobile.
Yes, lordship.
And because-
He needs some time, lordship.
He needs some time.
Yes, sir, lordship.
So he knows about the pendency of this matter.
Yes, Lord. He already retired from the service, lordship. That's all.
Oh, okay, okay.
Lordship may see the prayer for his promotion to that part already
been
done, you know,
Huh?
that part already being done.
Hmm.
He has already been promoted.
To the
SI.
post of sub-inspector with
Yes,
effect
yes,
from
yes.
97.
Who is already at 50 of her. Audit for was promoted to the rank of SI. During the pendency of the matter also he has been promoted.
No, but he wants with the effect from 97.
That part was.
So allow some time.
Madam, the problem is, this is a 2013 matter.
That's only 1 week's time, lordship.
You see, we have, even in 2018,
Yes, lordship.
you have asked for time on 1, 2, 3, 4 occasions. And in 2017, you were absent. 2000. As prayed for, this matter again. 2017. When will you have the instructions?
1 week, lordship.
Friday? Miss, what is your name?
M. Devi.
Miss M. Devi, learned counsel for the petitioner submits that, appraise that she may be given 3 days time to obtain instructions as to whether the petitioner is going to pursue the present case. According on the prayer of the petition, on the prayer of the council, this is the matter on 22.
Yes, lordship.
May it please your lordship. This is in this my lord's petition, the writ petitioner is challenging the rejection of the SBI bank. For though the petitioner was selected, he was rejected the appointment on the ground that he's medically unfit because of a condition which is an ankylosing spondylitis. Because of that condition, he was denied the employment, my lord. This is basically the grievance of the petitioner before your lordships. So I don't find the other side, but I am ready otherwise. The advertisement your lordship will find. at
Now what
page
to do?
The A. Parvez name is shown in the cause list.
You see, the problem is this matter was last listed
16, I think.
November 16.
Yes.
So 7 years. I think we have to give them
In
some.
fact, my file, we couldn't find, it was untraceable yesterday in the chamber. Ultimately, fortunately, the engaged counsel had a file, so I'm using his file. I'm missing my notes though, but anyway. So, your lordship may have it next week or so. It's an old matter.
They'll have to be informed about it. Who is the counsel for the SBI?
SBI, the name shown is Mr. A. Parvez, but there could be some change. I'm not sure. As doctor also appears, but as far as I know, generally on notice, they have amongst them, they are assigned. your lordship may have it on a day, particular day, and before that, I can find out who is.
Okay, right. Mr. K. Goswami, senior counsel appears for the petitioner. However, no one appears for the respondents. It is noticed that this case was last listed on 11/11/2016. As such, it would be prudent to wait for the appearance of the counsel for the respondent. You inform them?
I'll inform my lord. In the meantime, your lordship may have a list.
Mr. K.
fix a date.
Goswami submits that he will inform the counsels for the SBI regarding the pendency of this case, and that the matter will be listed on 21.
Any date, my lord?
Will be listed on 9/10.
9th October. Very well. I could
No, no, 9/10, they say 10/10.
10. Very well.
10/10, fixed. Okay, 12/10.
Well, yes, sir.
12/10. This is the matter on 12/10.
Deeply obliged.
I was quite surprised to see that cases have been listed after 10 years.
Yes, sir. That's quite long time.
Very long, very long.
And these are not those matters also where there is a stay or something.
Nothing, there's no stay. I do not know why the councils did not pursue the matter.
Sometimes what happens, my lord, if on the first day stay is not given, after a point, the petitioner is also.
Not interested, because contractual employee.
Yes,
also.
and the lawyers will obviously forget only.
They get paid by on the appearance date or something like that.
And
Something
in
like.
some cases, they don't.
Okay. And
Then
Both
BL
legs.
means both legs affected, but not arms. OL, one leg affected. So partially dead. The ideal is because I am rejected because I have a neck rigidity, spondylitis. Whereas you are open, you are giving this to a person who has problem in two legs or one arm also. I'm just trying to project that, my lord, only for that purpose. Now, if your lordship kindly come to page 16. This is part of clause 17, general information, Roman 8. Appointment of selected candidates is subject to
page 16.
page
where?
16 towards the right side, Roman 8. This is part of clause 17.
Yes.
Appointment of selected candidates is subject to their being found medically fit as per the requirement of the bank. Such appointment will also be subject to the service and conduct rules. I'm just showing your lordship to that condition. Then my application, your lordship will find at page 17. I applied for the post of assistant. That is at page 17. Then I appeared for the written test, and upon being qualified.
17.
Yes, 17 is my application for the post of assistant. Then at page 22, your lordship will find after being qualified in the written examination, I was called for an interview. This is my interview call letter 28/12. Accordingly, I appeared before the interview.
Call for interview, page 22.
Yes, yes, my lord. You're on the
Now,
top.
is it relevant?
Well,
for
it is the facts. After this, my lord, the result came at page 25. I have been selected. At page 28, my number is there.
Then
And then, my lord, I received a letter which is at page 36.
yes.
Page 36, 15, 11, 12. We are pleased to inform you that based on your performance in the written test held on so-and-so and subsequent personal interview, you have been selected for appointment in the bank in the clerical cadre as assistant subject to completion of required formalities by you. And one of the, at page 37, your lordship will find clause I, which says, for that purpose, following medical test reports from pathological laboratory, diagnostic center, radiological center will be required. The report should be signed by at least MD, qualified attending pathologist or radiologist. So this is what is was required, that I have to give the certificate. Accordingly, I have given the certificates at page 40. Your lordship will see everything is all right, except at page 45, your lordship will see no, your lordship,
Yes.
towards the end, known ankylosing spondylitis, no disease activity currently, no plan for biological at present. So it is of admitted fact that the petitioner has a condition called ankylosing spondylitis, which is rigidity in the neck region. And however, at that time, it was reported no disease activity currently. Surprisingly, at page 46, we have been rejected. Your lordship will get this impugned order, which is dated 4/12/12, with reference to offer of appointment letter issued by the Assistant General Manager, State Bank of India, so and so. We deeply regret for our inability to allow you to join in the bank service since you have been found medically unfit. Whether my condition would be an impediment to the job or not, this has not been assessed. Simply because I have ankylosing spondylitis, I have been held to be medically unfit. The relevant questions, according to me, has not been addressed by the officers, by the doctor concerned from the State Bank. In fact, when they had filed their affidavit in opposition, because what happens is that when we appeared in the interview and after the selection, I have to meet the doctor of the SBI. So when I had met the doctor, she asked me about my conditions. Obviously, I have divulged about my spondylitis problem. She said, get a certificate. We gave her the certificate. Then what happens, we don't know. Now, in the affidavit in opposition, they are annexing the report of the State Bank of India's doctor. That your lordship will find at page 30 in the affidavit in opposition. Now here, at page 16 is relevant. The reason is given why I am medically unfit. Page 16.
Yes.
This candidate is suffering from ankylosing spondylitis. He is a case of known ankylosing spondylitis with neck rigidity, which is a progressive disease. I have discussed his case with Dr. So-and-so, Chief Medical Officer, Corporate Center, Mumbai. According to so-and-so, he is not fit for bank as he is suffering from a progressive disease. Well, if somebody is suffering from an ailment, that itself will not make him medically unfit for the job, unless, of course, that condition will be an impediment to the performance of doing that job. The nature of job. Now, what is the nature of job of an assistant? Nothing has been shown here. Simply, and that also rejected because the concerned doctor in Bombay says, no, he's unfit. The concerned doctor in Bombay did not examine. Neither this lady doctor, Dr. Dharitri Deka, the medical officer of SBI, has also personally not examined the petitioner. Based on the reports, she has given this certificate. Now, we have filed our reply also. In our reply, if your lordship kindly see page 13 for a moment, I have indicated the nature of basically
13, we don't have any.
sorry, paragraph 13. I stand corrected. Paragraph 13.
Yes.
That in reply to the statements made in paragraph 14 of the affidavit in opposition, the answering deponent reiterates that he is not seeking appointment under the disabled category. The basic duties of clerical staff in bank are attending customers in the counter, assisting the customers to open deposit
Okay,
account.
anyway, so that's
Yes.
then So now what is your case? Any citations in support of your case?
Yes. Yep. The first case that I'm relying is AI, it's a division.
How many
bench.
cases are you relying upon?
One is AI 1997 Bombay 406 division bench.
Yeah, 1977.
1997 Bombay
1997.
97. 1997
Ah.
Bombay at page 406. My mark portion is actually on 9. Where is my book then? You can't read, yeah? Give me the my mark book, yeah?
Para?
Para 53. In this case, the candidate was suffering from HIV.
HIV.
Yes, and was rejected. Though it starts from 43, where they have, in fact, interestingly here, the respondent lawyer was Dr. Chandrachur Miller, the current CDI, of course, was arguing against what I am now placing. Para 53, my lord, I will rely on 53 and 54. May I read it, my lord?
Yes.
Thus, no person can be deprived of his right to livelihood except according to procedure established by law. Obviously, such procedure established by law has to be just, fair, and reasonable. In other words, such procedure also must have passed the rigor of Article 14. The rule providing that person must be medically fit before he is employed or to be continued while in employment is obviously with the object of ensuring that the person is capable of or continues to be capable of performing his normal job requirements, and that he does not pose a threat or health hazard to the persons or property at the workplace. The persons who are rendered incapable due to the ailment to perform their normal job functions, or who pose a threat to other persons at the workplace, say like due to having infected with some contagious disease which can be transmitted through the normal activities at the workplace, can be reasonably and justifiably denied employment or discontinued from the employment, in as much as such classification has an intelligible differentia, which has clear nexus with the object to be achieved, that is to ensure the capacity of such person to perform normal job functions, as also to safeguard the interest of other persons at the workplace. But the person who, though has some ailment, does not cease to be capable of performing the normal job functions, and who does not pose any threat to the interest of other persons at the workplace during his normal activities, cannot be included in the aforesaid class. Such inclusion in the said class merely on the ground of having an ailment is obviously arbitrary and unreasonable. That is what I was trying to demonstrate, my lord. Because here it is not their case that I shall not be able to perform my duty because of having spondylitis. And that cannot be their case, because they have identified this post for person with locomotor disability. That means it is capable. In fact, I am not even a disabled person. That's a different thing. I'm not even a disabled person. Well, there's one more case from SBI only. This is from Delhi High Court. No, Delhi hai to? From the Delhi High Court. This is also a case of an SBI appointment to the post of probationary. So here what happened? There were two reports, one in favor of the petitioner, one against the petitioner. Ultimately, the court referred the matter to the medical board. Medical board also gave a report in favor of the petitioner. And the report, both the favorable report says that here the condition of the petitioner was hemophilia. He was suffering from hemophilia. Now that apparently is not an impediment to the job profile. Now your lordship will find that paragraph 10. On perusal of paragraph 9, I may start with. Pursuant to the said order, medical board was constituted, which was headed by so and so. The report submitted by the medical board is as under. As per available medical records, it is deducted that Mr. So-and-so is a patient with hemophilia B disease with bilateral knee joint involvement as target joints. Hemophilia B is a hereditary disorder which can be prevented by prophylactic factor support. There is no record of any joint involvement of Mr. So-and-so or the frequency of his bleeding episodes or whether he is on so-and-so. Therefore, in reference to earlier opinion of doctor from AIIMS, as quoted in the Honorable Court's order, this vote is in concurrence to the fact that there is no impediment for Mr. So-and-so to join his job as probationary officer in State Bank of India. Paragraph 10. On perusal of the said report, it is emerged that petitioner is a patient with hemophilia B disease with bilateral knee joint involvement as target joints. The hemophilia B is a hereditary disorder which can be prevented by so-and-so. It is also recorded that there is no record of any joint involvement of the petitioner or the frequency of his bleeding episode or whether he is on any so-and-so. Petitioner is a 25-27-year-old so-and-so. Then paragraph 13, in view of the above submission, the impugned order is set aside. The consequently respondent is directed to appoint him as probationary officer with all consequential benefits. So there were two, initially there were two, because one that the petitioner gave and one what the medical officer of the SBI, which was against the petitioner. Ultimately, they went with the third. And it did 1995 6. That's short back. This is 1995 volume 6 Supreme Court cases 720. It's a very short judgment. We will supply a copy. Somehow they've missed having a second copy, but I'll just read it shortly, very short. 95 6 SSC 720. Admittedly, the appellant
Page
720. Three
Yes.
paragraphs only.
Yes.
Admittedly, the appellant is handicapped because of color blindness. He was admittedly selected by the Public Service Commission, but appointment could not be made on account of his handicap. When the matter came up on so-and-so, this court, while issuing notice, passed order as follows. Petitioner should also give the nature of the duties he has to perform and whether his color blindness would interfere with the discharge of the duties, discharge of his duties. Respondents also would state in this behalf of their stand. It is, if it is needed, they can also send the petitioner for medical examination by an expert government ophthalmologist or board. Close quotes. Despite the order, the government took no action in this behalf. 720. Towards the end in paragraph 2, after the quoted extracts. Despite the order, the government took no action in that behalf. On the other hand, the appellant had filed on 2595 an affidavit detailing that as per the information he had secured, there were 35 posts in the department and only 5 posts requires perfect vision without color blindness. Those 5 posts are mentioned in the affidavit. In other posts, color blindness was not an impediment for him to be appointed. Under these circumstances, we deem it just and proper that the government should consider the case of the appellant to be appointed to any of so-and-so, as mentioned by him in his affidavit. The appellant should. So just these 3 cases, I will not trouble your lordship with anything else. So my case otherwise is within a very narrow campus, my lord. Is medically unfit, simply saying will not do. It has to have some nexus with the job, the nature of job.
So your basic case is unless they say that he's incapable of doing the job, he cannot be denied.
That
appointment.
is one thing, and that has to be on some basis. They have to indicate what is the job, because that they cannot say.
What is your medical condition now?
In fact, I was said yesterday my junior call, and he says he's much better now. In fact, that report which that time he had given also shows that at present no current activity.
Anyway, let us.
So it
let
was
us-
something from the past he had.
Let us hear. the other
Yes.
side.
Maybe. Your lordship, please to fill paragraph 13 of my affidavit. No, please.
Para 13.
that while denying the statements made in para 11 of the writ petition, the answering respondent begged to submit that the fact that the petitioner is a case of ankylosing spondylitis with the neck stiffness is an admitted fact, and disease involves cervical region, hip joint limitation, and shoulder joint limitation. The disease of ankylosing spondylitis is a progressive disease. The disease is a chronic inflammatory arthritis with a predilection for the sacroiliac joints and spine. It is characterized by progressive suffering and fusion of the axial skeleton, and there is no cure of the disease. And this is the admitted fact in paragraph 2 of the writ petition. The petitioner has admitted in paragraph 2 of the writ petition. Paragraph 2. That the petitioner by way of his writ petition had impugned the action of the respondent banks, denying and depriving the petitioner the right of an appointment in the post of assistant despite of selection.
Okay, that is all right. Then what else?
Yes, my lord. And second thing is, the medical fitness was one of the conditions for appointment. And the report of the doctor of the bank paragraph 12.
12 of?
My affidavit of opposition. Note, the candidate may please note that they would have no right to appeal against the decision of the medical examiner. If, however, the bank is satisfied on the basis of the evidence produced before it.
Para 12 of the affidavit of opposition.
Page 12. Page 12.
Which para?
No, it is a part of the annexure.
Acha, say that.
Type copy of annexure.
Page 12.
Page 12. The
What is this? What is this note? Note is part of a.
Actually, there is no provision for appeal against the
Mr. Counsel, this note is part of what? Personal statement of
annexure
candidate.
A. Annexure A.
Annexure A. This annexure A has been made by whom?
This is a declaration by. I'm coming. Personal statement of the candidate. He has given personal statement, and based on his statement, the doctor has given his opinion.
But where does the doctor say that he is not capable of doing his
Yes,
job?
yes.
Where? Where does it say that?
I am. Page 16. Page 16. Unfit. This candidate is suffering from ankylosing
Okay, got it. So this is your case. Anything else?
And I have one judgment of the Honorable Supreme Court.
Yes, please give me.
I'm reading the head note.
Head note.
Yes. Otherwise, it is a short statement. I made it.
Then give me the particular paragraph.
Paragraph 7, Your Worship.
Paragraph 7.
Citation.
He is not going to tell
EIR
you. Sorry.
1994 Supreme Court 1241.
Yes.
We don't agree with the reasoning and the conclusion rendered by the tribunal. We are of the view that once the medical board and the appellate medical board found the respondent medically unfit for the post of scientific grade S, the tribunal has no jurisdiction whatsoever to have court over the medical opinion, and directed her appointment to the service. The tribunal,
Anything else besides this?
yes, my submission is that the object of selection is to select the best candidate. He is not fit for the post. And which I have stated in paragraph 13 of the affidavit in office.
You see, as per the note, I think the matter can be referred to a medical board.
Yes, that within 1 month.
No, now also, then this case is pending. Because you said that it is progressive. So if it's progressive, it will be to your advantage that they have a medical examination now after so many years. If it's progressive, so how many, when was this case filed? 2012.
2013.
So
13.
13. So 10 years later, if it's progressive, then the medical board will surely say that it has progressed and he's not fit to work. So let the medical board decide.
I'm agreeable to that, my lord.
I think that will decide everything.
And-
Because even your page 12, it talks of medical board.
Yes, ma'am.
And your judgment talks of medical board, not a
Appellate.
doctor.
Appellate also.
Appellate medical board and
But
medical
he has
board.
not opted for that. He has not opted for that. Instead, he has filed this. writ.
Naturally, because the doctor did not say that he's incapable of doing his job.
Correct.
He only
Yes,
said that the
he-
disease is progressive.
And plus that.
You see, similarly, supposing an HIV patient is there. HIV patient can do his job. The disease is a progressive disease. It manifests into a full-blown AIDS case after 10 years. At that time, long time back, it used to be 10 years. Now maybe 20, 30 years, I don't know. But whatever, just because the disease is progressive, does not mean that the person is incapable of doing a certain job.
Absolutely.
In your case, where is the doctor's statement that he's not able to do his job because of the disease? He just says that it is a progressive disease. So what?
No, he says that he is unfit for the job.
Will you say, what do you say about what do you say about a HIV patient?
No, HIV patient is totally different from this case. Because his nature of job is to sit in front of the computer all day. Not the HIV person. HIV patient.
Can sit whole day.
Where they
They can
orthopedically challenge
They-
people, they are
They can sit.
recruiting,
And
locomotor
he-
disability.
He has not applied for
No,
that.
but that is under the PWD.
Yes,
That's a
yes,
different.
why-
thing.
Why I am drawing that, my lord, because that indicate, because your lordship, the establishment has to identify posts where they can accommodate them.
Anyway,
Suppose they cannot, suppose the job demands that it cannot be, then an exemption has to be given. So here is a case which has been identified.
And
That a
even
person with locomotor disability and cerebral palsy is capable to perform the job. So if that is so, I am not even a disabled person. I am merely having some rigidity in my neck. Would you be depriving me of?
no, but one thing, you see, there are many issues actually.
My lord,
Because I have had this back pain.
my lord.
And one of the back pain is actually excavated by the sitting.
True, my lord. In fact, we almost, most of us lawyers are having all these, my lord,
Yeah.
spondylitis issues
Yeah.
because of our,
Sitting
but
habit.
then life has to go on.
No, but then that is, so there is some legitimacy in what he's trying to say.
My lord,
But the only thing is that the final decision
yes,
would have to be made by a medical board, not by us.
and
because ultimately it
And
is
my
for
lord,
that
there is
person.
no prayer
He is
for
going to
medical-
perform the job.
there is no prayer for sending the matter
No,
to the.
we are going to
No.
follow your document at page 12
No,
of the
it-
affidavit
it
of
was-
position.
It was their right to
It's your
file
lordship
within 1 month.
discretion.
I am admitting that. They could have filed within 1 month, but they have not.
No,
And
So-
even
so-
in
Copy
the
was
writ
not
petition,
given to
they have
us,
not
my
paid for that.
that copy was not given to
They-
us.
Not,
Yes, it is there.
No, it was given in the AO, not to us before that.
anyway, Mr. Counsel, I think this is the best way to do it.
And my lord,
Yeah.
maybe,
So you're not agreeable to it.
Yes, because there is no prayer.
Even if you're not agreeable to, if you're not agreeable to it,
Your lordship is.
then then you have got the right to go in appeal. There is no bar.
Yes, sir.
But this is my
But
In my view,
my submission is that there is no prayer for that.
there is no prayer.
There is
But
no
then,
prayer.
but
Yes.
can't the court mold the prayer?
Yes, yes.
Or give
Your
a,
lordship has right.
In fact, that decision of the Delhi High Court is also.
That is not applicable in this case. That is not applicable. My case is direct because the medical fitness was the sign qua non for the appointment.
mental fitness, there's no question of mental. Mentally, he
Medical,
passed.
medical. Medical. one.
Anyway, I will dispose it off, huh?
Yes, sir.
No, I'm going to give dictation. I cannot keep it all perfect. Then I'll have double workload. Again, read. Oh, 3 बजे. हाँ, बाद में हम बुलाएगा. I've got this CAV, that is the problem. You keep CAV, then unless you give dictation,
Your
you
lordship
forget.
will have to again read.
Again,
everything.
read.
Now your lordship has the time also. I don't think this will take a lot of time.
So we dispose of the case
My lord.
with the direction that depending upon the decision taken by the medical board as to whether he is fit to do the job, the appointment of the petitioner will be subject to that.
Very well,
decision.
that's all right. And maybe when the medical board is taking that call, both parties may be at liberty to give the nature of the job because
He has to
unless
apply
the
for
nature
that.
of the job of the assistant is given, perhaps it would be not. Anyway, I leave it.
It
to
will
your
be
lordship.
clear from this.
I leave it. to your lordship.
Heard Mr. K. Goswami, learned senior counsel, assisted by Mr. Learned counsel for the petitioner.
A
Also-
Parvez.
Also heard Mr. A. Parvesh, learned counsel for the State Bank of India. The petitioner's case in brief is that pursuant to an advertisement dated 1/3/2012 for filling up the post of assistant black bracket clerical grade bracket close under the State Bank of India, comma, the appellant took part in the selection process. Full stop. On being successful, comma, the petitioner was given an offer of appointment by letter dated 15/11/2012. Full stop. The petitioner was thereafter asked to undergo a medical test, and after having undergone the medical test, comma, the petitioner was informed by the respondent number 4, comma, about the inability of the SBI to allow the petitioner to join the post of assistant, as he was stated to have been found medically unfit. By letter dated 4/12/2012. Full stop. Next paragraph. The petitioner's counsel submits that the where is that medical certificate? Page 46.
Page 46. my lord.
Submits that the
$45.
medical report of the petitioner
In fact, your lordship will find it is given by Dr. Pradeep Sharma, a consultant rheumatologist. On top.
medical report of the petitioner issued by the bank doctor, by the bank doctor.
No, my lord,
Oh.
this is independent because
Okay.
we have to give these.
Okay, by the Excel Care, EXCL Care, Excel Care Hospitals Private Limited shows that the petitioner was was a known, in fact, a known
Ankylosing.
ankylosing, 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 spondylitis. Though there was no disease, invert commas, no disease activity currently, invert commas. Next paragraph. The petitioner's counsel submits that there being no finding or observation made by the hospital, by the doctor, to the effect that the petitioner was incapable of doing the job of an assistant, bracket clerical cadre under the bank, comma. The denial of appointment to the petitioner was arbitrary. Full stop. In support of his submission, the learned senior counsel has relied upon the judgments of the High Courts of Bombay and Delhi and the Supreme Court. No, High Court of Bombay and Delhi. There has relied upon the decisions of the Supreme Court in Dash versus Dash 1995 6 SCC 720, comma. The decision of the Bombay High Court in Dash versus Dash AIR 1997 Bombay 406 and the decision of the Delhi High Court in Dash versus Dash 2012 SCC online DEL 405. Next paragraph. So before that, just before that, you also write the petitioner's counsel further submits that though the petitioner was suffering from ankylosing spondylitis, but presently he is not suffering from any physical disability. Next para. Mr. A. Parvesh, the learned counsel for the SBI, submits that as per the doctor's report, comma, the petitioner's disease was a progressive disease. And as such, there was no infirmity with the decision of the SBI not to appoint the petitioner to the post of assistant. Assistant, comma, which involves sitting in the bank the whole day. Correct?
Yes.
He also submits that the bank Where does it say 1 month? Nothing says 1 month. In your
Yeah,
page
1
12.
month is there.
Where?
In the note portion, it is.
No?
Uh,
Okay, within
paragraph
1 month.
The candidate may please note that
Okay, okay. Yes, yes. Submits that the bank in terms of the note to the form to no,
annexure A.
huh? Yes,
Annexure A.
antitrust, huh? He also submits that in terms of the note to the personal statement of the candidate provided by the bank, comma, it has been clearly stated that no appeal would lie against the decision of a medical examiner. And if the petitioner could produce evidence regarding the possibility of an error of judgment in the decision of the medical examiner, comma, no, not comma, within 1 month, comma, the bank could allow an appeal to a medical board to be constituted by the bank. He submits that as the petitioner did not avail of the opportunity to challenge the decision of the medical examiner with regard to the petitioner's disease being a progressive disease within 1 month, comma, the decision of the medical examiner has to be treated to be final. As such, there was no infirmity in not appointing the petitioner to the post of assistant. In this regard, comma, he has relied upon the judgment of the Supreme Court in the case of Indian Council of Agricultural Research and another versus Shashi Gupta, reported in AIR 1994 SC 1241. Next part. I have heard the learned causes for the parties. The the submissions made by the counsels for the parties and the documents on record show that the medical examiner had stated that the petitioner was suffering from a known ankylosing spondylitis with neck rigidity, which was a progressive disease. The medical examiner, Dr. Dharitri Deka, Dharitri Deka, has also stated in his report that he had discussed the case with one Dr. Ajinkya, Ajinkya, comma, Chief Medical Officer, comma, Corporate Center, Mumbai, comma, who had stated that the petitioner was not fit for the bank as he was suffering from a progressive disease. The report of the medical examiner no, then though the report of the medical examiner states that the petitioner is suffering from a progressive disease and is unfit, comma. He has not stated that the petitioner was incapable of performing the normal job functions required of an assistant, bracket, clerical cadre or grade, clerical
Assistant.
clerical cadre in the bank. Next paragraph. In the case of MX of Bombay in Indian inhabitant, Supra, huh? The division bench of the Bombay High Court while considering the case of an HIV patient had held that no person can be deprived of his livelihood except according to procedure established by law. The rule providing that a person must be medically fit before he is employed or to be continued while in employment is obviously with the object of ensuring that the person is capable of or continues to be capable of performing his normal job requirements. And that he does not pose a threat or health hazard to the persons or property at the workplace. The persons who are rendered incapable, comma, due to an ailment to perform their normal job functions or who pose a risk to other persons at the workplace due to having been infected with some contagious disease which can be transmitted through normal activities at the workplace, comma, can be reasonable and justifiably denied employment or discontinued from employment, comma, inasmuch as such classification has an intelligible differentia which has clear nexus to the object to be achieved, viz. To ensure the capacity of such persons to perform normal job functions, so as also to safeguard the interests of other persons at the workplace. Full stop. But the person who, comma, though has some ailment does not cease to be capable of performing the normal job function and who does not pose any threat to the interests of other persons at the workplace during his normal activities cannot be included in the aforesaid class. Full stop. It thus held that denying employment merely on the ground of having an ailment is arbitrary and unreasonable. Full stop. In the case of Delhi High Court is not this. What is this?
Delhi High Court, before the Delhi High Court, there were two reports. One which the petitioner got, which was in his favor. Then the medical officer of the state bank
I think
had given an adverse.
the 2012 SC Delhi has not.
It's Anil Kumar's case, my lord. Anil Kumar petitioner. 2012 SSC Online Delhi 4005. Then the court ordered for another medical, referred the matter to a medical court. That report was also in favor of the petition. Based on that, the appointment was given with consequential benefits.
In the case of Anil Kumar Supra, Anil Kumar versus SBI Supra, the petitioner therein was directed to be appointed as a probationary officer, as the medical report made by the medical board was of the view that there was no impediment for him to join his post as a probationary officer in this SBI, though he was suffering from hemophilia B disease with bilateral knee joint involvement as target joints. Next para. In the case of Nand Kumar Narayan Rao Godmare, Supra. The appellant was not appointed on account of his handicap, that is color blindness. though the Supreme Court had directed that if needed, the government could send the petitioner therein for medical examination by an expert government ophthalmologist or board. No action was taken by the government. On the other hand, the petitioner had filed an affidavit stating that only 5 out of 35 posts in the department required perfect vision without color blindness. Under the above circumstances, the Supreme Court directed to government to consider the case of the petitioner for appointment to the post of agricultural officer. Next. In the case of Indian Council of Agricultural Research and another Supra. The Supreme Court held that once the medical board and the appellate medical board had found the respondent medically unfit for the post of scientific grade S, the Central Administrative Tribunal, New Delhi, had no jurisdiction to go over the medical opinions and direct the appointment of the respondent. To the post of scientist grade S. It further held that medical fitness is the sine qua non for appointment to public services, and it is the inherent right of an employer to be satisfied about the medical fitness of a person before offering employment to him/her. Para 7. Okay. Next. As next para, as stated earlier, as can be seen from the foregoing paragraphs, and the documents on record, there is no medical opinion stating that the appellant, the petitioner, is unfit or incapable to perform the normal job functions of an assistant bracket clerical cadre in the bank. The only statement made by the medical officer is that he is unfit due to the petitioner that the petitioner's disease being a progressive disease. Full stop. In view of the above, comma, it is the view of this court that no, not in view of the judgments referred to above also show that medical fitness is the sine qua non for appointment in public service unless posts reserved for persons under the Persons with Disabilities Act 1995 is to be filled up. Full stop. As the judgments referred to above provide for examination of a candidate for appointment to a post by a medical board. Come on, this court is also of the view that a medical board should examine the case of the petitioner and take a decision as to whether the petitioner is able to render the normal job functions assigned to an assistant bracket clerical grade. Full stop. Accordingly, in terms of full stop, though the 1 month period provided for referring the decision of a medical examiner to a medical board has expired, however, this court is of the view that a medical board should be constituted by the SBI to examine the petitioner in terms of the note given in the note, as per the note given in the personal statement form of the candidate pertaining to posts in the SBI. First stop. Accordingly, the respondent shall constitute a medical board within a period of 1 month. Within a period of 1 month from the date of from today.
From the date of receipt of.
From the date of receipt of a certified copy disorder. And inform the petitioner. Who should inform the petitioner to be present for medical examination on a date to be fixed by the medical board. The medical board
The government, doctor.
No, out here the note says by the bank.
SBI notes.
As a-
That notes, my lord, with
As per
utmost
SBI.
respect, my lord, that was never communicated that the decision, so that will not come here. In fact, in the SBI case only, that Anil Kumar, Delhi is an SBI case. There it was referred to Director Ames to constitute a medical. Let there be an independent board because the medical officer of SBI has already given its opinion. And as per.
Medical board has not given a.
Medical officer.
Medical
Dr.
officer.
Dharitri Deka is a medical officer of SBI. She has given her.
No, no, we say that this doctor shall not be a part of the board.
But let them have government certified doctors, it will be neutral, my lord. Which is only to that effect.
The rule is
We'll
that.
go by the board, my let him.
Board constituted by the State Bank of India. This is.
That is what, that is there. It is there. No, that is there. It's okay. Yes, whatever I said. Whatever I said. Shall consist of at least 3 doctors. One of whom shall be a specialist in the particular field of ankylosing spondylitis.
I think it would be a remote,
It'll be orthopedic
remologist,
surgeon.
probably a remologist,
Shall be a specialist
specialist.
in the field, in the disease, in regard to, in relation to the disease
Correct.
suffered by the petitioner, that is ankylosing spondylitis. What's up? The medical board shall specifically state as to whether the petitioner's disease would make him incapable of performing the normal job functions of an assistant, bracket clerical grade. Full stop. The state respondents, the respondent shall thereafter issue necessary orders in pursuant to the final decision to be taken by the medical board.
But one post was already directed to be kept vacant on the first order only, that is dated. Order dated. I think it is order dated 24/1/30. In view of the above, after hearing, let it come from the petitioner and on perusal of the materials on record, it is hereby ordered that one post of assistant clerical cadre in under the respondent shall be kept vacant until further order. And by the next
Full
order,
stop. The fate of the one post of assistant bracket clerical cadre under the SBI, which had been kept vacant by order dated 24/1/2013, shall accordingly. What do I said? Shall accordingly be decided on the basis of the final decision of the medical board.
usually that with consequential benefit. I don't want back wages since we didn't work, but at least the other consequential benefit should be
But-
given.
No,
In
you are not
case-
even born into the cadre right now.
Well, not- Because that's because a wrong has been done, because in that Anil Kumar case, appointment was given with all consequential benefits, except back wages was not given.
This is not a case of promotion.
It's appointment,
know-
otherwise senior, the people who are juniors to me will all.
The writ
be
petition is accordingly disposed.
It leave your place, madam.